Good morning, all. This hearing is in the matter of CFI 041-2021, and it's being held by way of video conferencing before His Excellency Justice Andrew Moran, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by Simmons & Simmons Middle East. Lead counsel is Mr. Ben Hubble, KC. The defendants are represented by Al-Tamimi and Company. Lead counsel is Mr. Jamie Smith, KC. Thank you, Your Honour.
Thank you, Lina. Right. So back to housekeeping matters, if I may. I wanted to raise with you how you wish to deal with the document production requests and the responses to them, whether you wish to proceed in the normal way with Mr. Hubble making his submissions as to why I should make document production orders on the maintained requests, and then hearing from Mr. Smith, or whether it might be better, I'm in your hands on this, for us to take request for an order one by one, so that I hear you on a request and then hear the response to that request and proceed in that manner. I'm open to doing it that way, if that is how you would prefer to do it. It's obviously likely I will require time to reflect on your submissions and let you have my decisions in coming days. So it's not that I would be able to say to you, having heard your submissions, I'll make an order, or I'm not making an order on that particular request. That also gives rise to some difficulty, which I think can be easily overcome, which relates to timetabling towards the trial. A substantial objection is raised as to maintaining the existing dates by the defendant in the event that I made substantial document production orders. It is suggested that the length of time that it would take to process those orders and comply with them would result in it being impossible to have a fair trial and people be ready for trial when the matter is listed in October next year. And I think Mr. Smith, the defendant's proposal in the event that I did make extensive production orders would be that the trial should be put back to a date, or not before a date, in March. I can't remember the precise date you advanced, but March 2027. So I'll give you a minute if you wish to confer on that. I'll turn off my microphone and camera while you deal with that, if you wish to do so. The other matter I wish to raise with you at the outset, and this is not a criticism, because obviously you've been working together to try and narrow differences. It appears there may be some inconsistency between the maintain requests in the Redfern schedule at hearing bundle page 3947, the claimant's Redfern schedule, the draft order, and the skeleton argument. So I need you to make clear precisely what orders are now being sought in the submissions that you make. It may be that I've not appreciated the nuances of possible additions, as it were, or limitations to document production orders that are being sought, different search parameters and so forth that may or may not have been agreed. So I'd like you to make that clear to me in the course of your submissions. So that's an important aspect of it. The next matter I'd like to raise with you is, as is rightly pointed out by the defendant side, document production in the DIFC follows the arbitration model rather than the curial model. And with the former, generally reasons are not given in the interests of speed and efficiency for the making or refusing document production orders. And that's because the decision usually depends on a balance of competing arguments resolved by arbitrators or judges, weighing the considerations listed in this court in RDC 2828. Apart from where there is a legal objection, such as for request 15, relating to the evidence of Mr. Navalkar to the DFSA, where the reason for a decision requiring or refusing production is likely to be that the court is simply persuaded that the arguments for or against production outweigh the arguments to the contrary. I'm going to ask, does either party contend that the court should do anything more than make its orders one way or the other without reasons? I would probably give some introductory reasons explaining my approach, which is trite, obviously, and there's no issue about the actual approach. But in terms of recording the decisions, as one would normally do in a Redfern schedule, where reasons are not given, does either party contend that I ought to be giving any form of reasons or simply just making or refusing an order? I'd like you to respond to that, if you will. In terms of the timetable, it seems to me that I'm going to have to hear your submissions today on a contingency basis as to what the contingency will be, obviously, what extent of document production orders I make, and what that will involve, what are the time implications upon making those orders. I don't want to have to reconvene this hearing, so I would like to hear your submissions, as I say, on a contingent basis as to whether the trial timetable as modified and as now found at the annex to the claimant's skeleton argument, whether that can be maintained or whether inevitably the matter would have to be adjourned to allow for a proper periods of time for all the procedural steps between now and a hearing, a trial hearing. Let me see. I think that is everything I wanted to raise with you at the outset.
Well, are we going offline for a bit anyway? So.
Yes, one thing I think I ought to raise for you to address me on, it's something that inevitably arises as a possibility in a case of this type. And again, the possibility is greater or less depending on what orders for disclosure I make, that there may be yet further applications to amend the particulars of claim, and that will be a factor that will have to be borne in mind when considering whether the present timetable or the slightly amended timetable is maintainable or not. So I'd like to hear you at a moment of your choosing on that particular issue as well. And finally, there is one other thing, of course, and that is the application to amend the third amendment to the present amended particulars of claim. I get the impression that it's accepted by the claimant that that is not something that can be dealt with today, and that the defendant has indicated that it will state its position and whether there is any contest in relation to the application to amend by the 3rd of November, with a prompt timetabling of determination of that application depending on the scope of contestation, if I can put it that way. So if you could just make that clear as well, that it's agreed that that is the way we will deal with the extant application to re-amend the particulars of claim. So that is all I wish to raise at the outset. I'll take it in turns with you each. But if there's anything else that either of you wish to raise in responding to me now, perhaps you would also raise any matter that you wish to have me consider or raise with the other side, as it were. So, Mr. Hubble, can I come to you first of all on those matters?
Your Honour, yes, thank you very much for those indications and observations, which are very helpful. I've reduced my note indicates 6 points, and if I deal with those briefly, because one or two of them I will be addressing in slightly more detail in the course of my submissions in any event.
Yes.
But the first point you raise, Your Honour, is the question of whether, in relation to the claimant's DPOA, it would be sensible for you to hear from me in relation to all of the claimant's requests, and then to hear from Mr. Smith, or whether they should be dealt with seriatim. I do understand that there are cases in which it would be appropriate to deal with them seriatim, but my suggestion to Your Honour would be to hear from me first in relation to all the requests. The reason for that is that there are certain overarching general points that I would want to make, and that certain of the requests can be described as allied, and in my submission it would be helpful for the court to see the shape of the litigation and the requests as a whole and hear my submissions in one go. So that's my proposal in relation to the claimant's application. The second point Your Honour raised is the question of being completely clear what orders the source in relation to each of the requests, and we completely understand and take that point on board. This application has come on thanks to the court's cooperation relatively swiftly, and there perhaps hasn't been the process of liaison and dialogue that there might ordinarily have been between the parties, and things have been moving in relation to certain of the requests, and I will endeavour to clarify that as I go through.
Thank you very much.
In relation to reasons, Your Honour, our overriding criteria is to try and keep the trial date and to keep, as it were, things moving, and we wouldn't want to hold up the court's decision for, as it were, long mini judgments in relation to each of the requests. Yeah. Though we anticipate that perhaps an introductory and overarching statement of reasons and factors would be of assistance to the parties.
Yes.
Timetabling, I will deal with in my submissions, if I may. That turns in considerable part upon the spectre of what the defendants raise, that the trial can't be kept if there's a substantial order for production, and that depends upon that varies from request to request and the type of document that's sought, and there are also issues in relation to actually whether progress can be made between the parties by refining search terms. So I'll deal with that. The fifth point that you raised, Your Honour, was the question of whether there might be further applications to amend. And the short answer to that is I don't think that can be excluded. We have moved as quickly as we can to prepare our draft third amended particulars of claim based on finally being provided with the audit files for AIML and ACLD, but we haven't yet seen the audit files for AH, the holding company. Yes. So we certainly don't positively further amend at the moment, but I can't entirely exclude that possibility. And then the position in relation to the application to amend that we have issued is, I'll come on to this when I do my stock take, but as I understand it, the defendant's position is they're going to tell us whether they consent or not to that by Monday, the 3rd of November. And in those circumstances, and in light of the work the parties have been doing to prepare for this application, I'm not seeking to press upon the court that you should resolve that the application to amend as part of this hearing. I suspect that both days of this hearing will be taken up with production order matters.
Very well. Well, that's very helpful. Thank you very much. Mr. Smith, on those points?
Your Honour, so dealing with those in turn, order of submissions, I've heard what my learned friend has said. I wouldn't wish to persuade you to the contrary. One issue that you will find is that if my learned friend goes through his submissions in the order of his written skeleton, you will not find him dealing with the requests in serial order.
I can cope. I can cope with that. Don't worry.
I mention that because there may not be a complete correspondence between the order in which he deals with the requests and the order in which I deal with them, and so in many ways, probably the fact that we all do it together in one go is probably better.
Very well. I'm persuaded that I should stick to the conventional approach and hear you both in full, and there will, of course, be a transcript. I understand. Well, that's something I might mention. I understand that the parties have engaged the services of Opus, which is welcome. I would like to have my own login arrangements with the Opus platform, because of course Opus provides, I use it regularly, as you'll understand, in my other life as an arbitrator, but it has a lot of facilities that are useful for managing cases and submissions and dealing with evidence and everything else. So I don't want you to give me an answer to that now, but I raise it because I'd meant to raise it and I forgot to raise it. I'd like that to be explored and the court's notified as to what arrangements can be put in place for me to have the usual arbitrator-like secure access to the Opus platform for my own use in relation to the documents that are uploaded to it. I don't know whether at this stage you've actually engaged Opus to manage the document bundles, or if it's simply for transcription services. But this is something that can be dealt with down the track, as it were. But I've mentioned it now. So, come to the second point.
So number two, that there are differences. In some respects, you'll hear submissions from me that they are inappropriate differences, and what the claimants are seeking to do is to extend the scope of the requests. But we can deal with that when we come to the particular requests.
Very well.
Number three, in terms of reasons, I share my learned friend's view on that. You've touched upon request 15, which may be more legalistic. And it may be in that regard that some outline reasons would be of assistance. But the bottom line, Your Honour, is that we too would not wish to burden you with anything more than indicating your decision.
Yep.
Number four, the timetable and the contingency of submissions. Certainly, you already rehearsed what our essential position is, which is that if we are required to produce a major part of what is sought from us, that we say that it's simply going to take too long for there to be a fair trial. And yes, you're right that we would propose a postponement of the trial until March of the following year. So that is the essential position, but of course I can explain that more fully when we come to look at the timetable.
Indeed.
Number 5, in terms of applications to amend, we certainly anticipate that there will be a series of amendments. When we come to have a look at the terms of what we've called the TAPOC, the third amended particulars of claim, you will see often that where there are new particulars, there are also the words in brackets subject to further document production. And so I think, as my learned friend very fairly recognises, it's far from unlikely that there will be rolling amendments to the case. And indeed, the burden of my learned friend's argument on many requests is that they need the material in order properly to understand the case. So that's.
I should tell you, I've should have told you what I've read. I've read everything I've been asked to read in the skeleton arguments, the pleadings, and the proposed third amended particulars of claim, the purple amendments in it. So I've read those. So and indeed that's why I asked the question about the likelihood of future amendments, because of course that does feed into the timetable issue as well.
It does, and you'll readily appreciate that as the case is moving, so the experts are going to have to move with it. So forgive me, that these will be submissions in due course. And then sixthly and finally, the application to amend, Your Honour has it entirely right. We've agreed, I understand it to be agreed, and my learned friend has confirmed that we will not be having substantive argument on the amendments over the next 2 days. But by Monday of next week, we will indicate our position one way or another. If it is consent, then depending on the other timetabling issues, there will be a timetable.
Right. Well, that's fine. I'm grateful to you both for dealing with those questions. I think we're ready to begin, unless either of you have anything else you wish to raise with me by way of housekeeping. Mr. Smith, nothing from you?
No, Your Honour.
And Mr. Hubble?
No, thank you, Your Honour.
Right. Well, we'll begin then. Mr. Hubble.
Thank you, Your Honour. So I was going to first deal with a brief introduction and agenda, some of which we've covered in the course of the submissions you've invited just this morning, Your Honour. So in broad terms, there are 4 matters before the court today and for the hearing tomorrow. The first is the claimant's DPO application dated the 18th of September 2025, which has been condensed down to the Redfern schedule, which one finds at 3946 in the bundle. And I'm going to be coming on to make my substantive submissions in relation to that, so I won't summarise the issues in it because I'm going to come on to deal with them. The second issue is the defendant's document production order application, likewise dated the 18th of September 2025, which is at tab 20, page 2712. Insofar as there is anything arising from it that need trouble the court, my colleague Mr. Edmonds is going to deal with that. But my understanding is that no formal order is sought by the defendants in relation to that application. Then third, there is the claimant's application to re-amend the particulars of claim, which Your Honour knows the application was issued on the 22nd of October 2025, and Your Honour has kindly indicated that you've read the amendments already, and the position is that the defendants are going to indicate their consent or otherwise by the 3rd of November 2025. The footnote that I mention at this stage in relation to timetabling is one matter to consider when one comes to the timetable, which may interrelate with when Your Honour is in a position to provide an answer in relation to the claimant's DPO application and the implications of that. But one question will be the possibility of contingent directions for an early determination of that application to amend if it is necessary. So I flag that as something that would need to be among the matters considered when one comes on to timetabling.
Well, perhaps at an appropriate gap in the proceedings, you might be able to agree contingent directions for that determination of that application if it is not consented to in whole or in part.
My lord, well, Your Honour, that sounds sensible, and of course we will have, in all likelihood, we're going to have overnight when we might have the opportunity to liaise counsel in relation to that issue.
That would be helpful.
And then the first three issues I've identified all interrelate with the fourth issue, which is directions to trial, which, as Your Honour knows, is due to commence on the 12th of October 2026. And there is a measure, there appears to be a considerable measure of agreement between the parties in relation to that trial timetable, subject to the outcome of the DPOA, the claimant's defendant production order application, where I think there is an important issue where we require the court's assistance, where the defendant's position is if there is substantial production to be provided pursuant to the claimant's application, there can't be a trial in October 2026. And the claimant's position is that that is unduly pessimistic, because for certain categories of document, they ought to be capable of being provided very swiftly and easily. And for other categories, if there's a sensible process of liaison in relation to the ambit of searches, they need not be anything like the burden which the defendants are maintaining. And I think that's the essential shape of that dispute.
So those submissions are bound to be contingent as well, of course, on the outcome of the DPO.
Absolutely, they are, and that I understand, Your Honour, that this case has been docketed to you, and there may well be scope for a further hearing at some stage when Your Honour has given your indication in relation to the outcome of the claimant's application for document production orders, because that may then be the launch pad on which to really grapple with the question of directions through to trial. Our aim and our desire is simply to have as efficient a process as possible, so that interim hearings don't in themselves create a momentum towards losing the trial date.
Yeah, I understand your position. Thank you very much.
So if I may, Your Honour, turn to the first agenda item, the claimant's DPO application. I'm very grateful for the court indicating the documents that have been read. In terms of the structure of my submissions, I propose to make 5 introductory or overarching points, and then to deal with the requests on a broadly sequential basis, although, as my learned friend Mr. Smith alluded to, there may be some reordering so that submissions on allied requests can be dealt with together. And I anticipate that, as it were, I will speed up. So if Your Honour is concerned I'm going a little slowly at the beginning, that's because I'm covering ground that is likely to be applicable across the board. And so the submissions will probably become swifter and narrower on requests as we work through them. The first introductory point, Your Honour, relates to the material background to the claim. Certainly what is material so far as the claimant's application is concerned. And this has been addressed by both parties in their skeleton argument. So I don't want to repeat those matters at length, but if I may, I wish to highlight certain key points.
Where in your skeleton should I go for this?
The background is dealt with at page 3886 and.
Sorry,
yes.
can I have paragraph numbers, please? Because
yes.
I worked on both of your skeleton
course.
arguments as separate documents.
Well, that's very helpful. The story picks up from paragraph 2 of our skeleton argument. Although in relation to this very first point, I've been endeavouring to sort of synthesize what both parties have flagged up and what we say is important. The first, as Your Honour will know, is that this is a substantial audit negligence claim that arises from what the claimants submit were negligent audits performed by the defendants for the financial years FY13 to FY17 for the first claimant AIML and FY14 to FY17 for the second claimant ACLD.
Yes.
Your Honour will have identified that the claim is very sizable. The quantum is presently put at a minimum of $600 million and potentially well in excess of $1 billion US. It is set down for a 10-week trial commencing on the 12th of October 2026. And the quantum and scale of these proceedings are, we submit, important factors for the court to have in mind when considering objections in relation to proportionality and the burden of any searches.
Yes.
So far as the first claimant AIML is concerned, it's registered in the Cayman Islands. It was audited by the Dubai branch of KPMG LG, which is the first defendant, which was also registered in the Cayman Islands. And AIML, as the name suggests, was the investment manager for a considerable number of funds set up by the Abraaj Group. And prior to its collapse, the Abraaj Group purported to have some $14 billion of assets under management. The second claimant, ACLD, is registered in the DIFC and was audited by the second defendant, KPMG LLP, also registered in the DIFC. And the second defendant, ACLD, sorry, the second claimant, ACLD, unlike AIML, was authorised and regulated by the DFSA. I'll refer compendiously to the two KPMG entities as either KPMG or the defendants. Your Honour will have this point, I'm sure, I know from the structure chart and from reading the pleadings. But ACLD was 100% owned by AIML, and AIML was in turn 100% owned by the parent company, Abraaj Holdings, which entity I will refer to as AH. And AH features centrally in relation to the request for document production orders. And that's because KPMG were not just auditors to AIML and ACLD respectively. KPMG were also the group auditors who carried out the group audit on the Abraaj Group as a whole, and in particular the audit of the parent company AH and AH's consolidated financial statements.
Sorry, was it the first or second defendant that was responsible for the audit of the holding, AH, I'll refer to it?
Yes.
KPMG LG, the first defendant, was responsible for the audit of AH.
Thank you.
Now, the court may very well be familiar with the factual and legal issues that arise on large-scale audit negligence proceedings of this sort, and I'm absolutely not in the business of teaching my grandfather to suck eggs, but can I just identify a few points that in very broad terms are going to arise at trial, and they're relevant to highlight because they feed into the claimant's requests. First, most obviously, the claimants must establish breach of duty against the defendants, namely whether the audits undertaken were negligent in failing to comply with the ISAs and in failing to comply with the standards reasonably to be expected of auditors who are members of one of the big four audit networks. And this will necessarily involve a close analysis of what the auditors did or did not do by way of audit work in terms of understanding the audit entities, planning the audit, undertaking the audit work and reporting to management and those charged with governance of the audit entity. which here would include the board of the parent company, AH. And that will include consideration of the interactions between the auditors and the claimant's management, and that will also involve consideration of expert evidence. But in short, it will be necessary for the courts to have a complete picture of what the auditors did or did not know, what audit work they did or did not do, and what reports were made to management and to those charged with governance. Second, the claimants will be required to establish causation. And so far as factual causation is concerned, that will involve considering what would have happened had the auditors, so we say, undertaken their audit work properly and in compliance with the ISAs. And we say that a host of financial irregularities would have been, and concerns would have been uncovered, and they would have been reported to those charged with governance, and that would have resulted in investigations and either the financial misconduct being prevented thereafter, or if no proper investigations were undertaken and the auditors couldn't be satisfied, the auditors wouldn't be in a position to provide clean audit opinions and would ultimately have had to resign. And that again will involve a very close analysis of what the defendants should have uncovered and what the defendants should have reported, and what innocent board members of the AH board would have done as a result. Then, of course, one would need to move on to the counterfactual and what would have happened if there had been reports to those charged with governance, and depending on what the result of those investigations would have been. And Your Honour will have seen that two alternative counterfactual situations are postulated in the re-amended particulars of claim. One, financial conduct would have been prevented and the Abraaj group and the claimants got onto an even keel. That's then a solvent counterfactual, and one has to look at what the position would have been had, as it were, the group, including AIML and ACLD, been able to trade out. The alternative, an insolvent counterfactual, is that it wouldn't have been possible to solvently restructure the group, and there would have been an earlier and more orderly insolvency. And either way, we say there would have been a very significant difference in the financial outcome for AIML and ACLD, and a massive reduction in the liabilities that they eventually incurred. Now, when one thinks about all those issues, a key issue at trial is likely to be not just in isolation the financial position of AIML and ACLD, but also the true financial position of the parent company, AH. And that's because AIML and so ACLD, presumably in this scenario, would have been dependent on the financial support and covenant of the parent company, AH. In other words, what would have happened to AIML and ACLD necessarily falls to be considered in the context of what would have happened to AH and the Abraaj group as a whole. So the central point is when you're dealing with a group and a group audit, it is unrealistic, and it is not placing the court in the best place to resolve matters fairly between the parties at trial if AIML and ACLD are viewed in a vacuum. It's going to be necessary to view the audit work that was done in the context of the group audit and what was known by the auditors. And when one comes to consider questions of causation and loss, what the alternative counterfactual position of AIML and ACLD would have been within the context of that group.
Yes.
I need only mention them briefly at this stage, Your Honour, but Your Honour will have picked up from the pleadings that there are the defendants deny breach of duty, they deny causation, say that they were as much the victim of the fraud as anyone else, and But significantly, in terms of requests, they also raise certain defences based on purported limitations of liability and contractual time bars. So I don't think I need to take you to it, but it's paragraph 67 to 70 of the defence and counterclaim at page 158.
Is this the fourth separate feature of the trial in prospect?
Yes.
Yeah, very well.
Yeah. Apologies,
no, don't worry. You didn't introduce it with a number, but
the fourth point is that in addition to issues in respect of breach, causation, and loss, there will be a material issue at trial in relation to the defendant's reliance on limitations of liability and contractual time bar clauses, which they say are applicable as a result of the standard terms comprised within engagement letters.
Yes.
And there are certain issues that arise in relation to those terms, but at the forefront of them will be the question of whether the limitation of liability clause, which purports to cap liability to only fees under each engagement letter, is reasonable under the implied terms law, which it is broadly similar to that of UCTA and the issues that arise under UCTA as to whether such terms are established to be reasonable. And similarly, there is a 4-year contractual time bar clause, which is purported by the defendants to say to apply and be binding, which, if applicable, would prima facie remove a claim in respect of FY13 and FY14. So there is going to be a heavy focus on at trial on the engagement letters and the terms and circumstances in which they were entered into, because those will be the circumstances in which the court will have to take into account for resolving the question of reasonableness. So against that, the two fundamental points then from that overview is first, by any yardstick, this is a complex and high value claim. And second, the factual and legal issues to be resolved will require a close analysis of the defendant's audit work by reference to all the available evidence and the wider financial position of the group, again by reference to all the available evidence. Turning then to my second introductory point, which I need to deal with only briefly in light of what the court has indicated as to its pre-reading, it is the procedural background. The court will have seen differing views have been expressed about the procedural conduct of the parties to date. I don't propose to dwell on that, as the court will wish to focus on addressing matters as they now stand before it.
Yes, that's absolutely correct. I can tell you immediately that it's not profitable or useful to go over that ground. We are where we are, and I have to bring this matter to trial fairly and justly, and that is what I intend to do.
Absolutely, Your Honour. That was very much my point that I was hoping to make. The one submission I do make, which I will return to in due course, and again, this is not an issue of allocation of blame, it's just a reflection of where we are, it is there simply has not been the time. There's been a flurry of correspondence late last week and yesterday in which the claimants have been seeking to understand the nature of the searches that the defendants have undertaken that are said to have given rise to this very large number of hits and this very large cost of review. And as my essential submission is that there is a great deal more that can be achieved by liaison between the parties to narrow the scope of those searches. And that process simply hasn't really happened. to date. We've had evidence put forward as to the number of hits, but when it was put forward, it was without any information in relation to number of custodians and search terms, and that process is literally just starting to emerge as a result of correspondence on Friday and Monday. But it is not, we invite the court to conclude, as simple as saying there's a huge number of hits and by certain searches, and therefore this review is going to be impossible. My third introductory point is the legal principles to be applied on a DPO application. And this has been addressed by the defendants in their skeleton argument at paragraphs 18 to 25. And the court will be very familiar with the approach. And of course, as the court has identified, it draws on the arbitration approach, which again, the court will be very familiar with. I make these short observations in relation to the approach which I invite the court to adopt. We say that the defendant skeleton does adopt in those paragraphs 18 to 25 an unduly restrictive approach to the rules in relation to production and document production applications, certainly in relation to litigation such as this. The defendant's skeleton arguments of paragraphs 18 to 19 sets out correctly that the situation in the DIFC is different to disclosure under, say, the CPR in England and Wales.
Yes.
With a key distinguishing feature being that a party only has to produce documents on which it relies in the DIFC, and a party does not have to produce documents which might harm its case. But we submit that that is a feature that actually reinforces the importance of the request to produce process. Party does not have to disclose documents adverse to its case, so such documents may well only be flushed out as a result of the request to produce process. That means that the recipient of the request to produce may have every reason to object to a request to produce and to complain about the burden that such a request will give rise to. And we submit that that means the court shouldn't take an unduly narrow and restrictive approach to request to produce, but should stand back and assess the circumstances of the case and identify whether the documents in question are likely to be sufficiently relevant or material. The court will, of course, pay close regard to RDC 28.28 and the requirement of sufficient relevance or materiality, the question of whether there's an unreasonable burden to produce the requested evidence, and considerations as listed at subparagraph 7 of procedural economy, proportionality, fairness, and equality. Taking that first subparagraph, the requirement of sufficient relevance or materiality, we in our submission, that is a deliberately flexible test which falls to be applied by reference to the circumstances of any given case. It does not mean bounds to be relevant or material. In our submission, it means that there is reason to anticipate that the documents would be relevant or material to the issues to be determined by the court. Because, of course, the requests haven't happened yet, haven't been answered yet. So the court has to take a sensible approach to applying that test. The aim of this exercise is for huge sums of money not to be spent chasing after irrelevant documentation. But in a case, particularly in the case of this scale, in my submission, it is going to be appropriate for there to be a review process, but there's reason to anticipate that the documents will be relevant or material. So far as item 3, unreasonable burdens produced, is concerned, the questions of burden and proportionality have to be considered in the context of a claim for at least $600 million and likely more. And second, if Your Honour has the DIFC Courts Practice second edition, if you happen to have that document.
I have it open in front of me.
Yes, there you are. I simply highlight the courts to page 617 and 28.28.2, the court's exclusion of documents from production, and the reference to the Orient insurance case there.
Yes.
Justice Giles declined to find the production would be unreasonably burdensome or disproportionate, noting that the claimant had revised its request to limit their scope to particular documents or documents of a particular description. The defendant had failed to explain in detail the alleged burden that would fall on it. The claimant had taken a significant position in declining cover and avoiding the policy, and there was a not insignificant amount at stake. The point I make there is, particularly because of the circumstances in which and the speed in which these applications have come on, the court should be wary of just saying or accepting at face value. The defendants say there's going to be a huge number of hits, therefore there's going to be an enormous burden. One's got to scratch beneath the surface in relation to that and identify whether actually there are ways to cut through this. So in summary, so far as the test to be applied is concerned, we submit the court shouldn't adopt an overly restrictive approach to the request to produce, because the result may be that important adverse documents are not available to the court. And further, particularly in a case as large scale and complex as this one, issues of burden and proportionality must be approached realistically, and they should be capable of being managed by sensible liaison between the parties, in particular in relation to the scope of searches to be undertaken. So that brings me to my fourth introductory point, which is the alleged burden that the claimants submit the request to produce would give rise to. At this stage, I'm just going to provide the court with some references in relation to the most recent correspondence on this issue, and I'll come back to it. But there have been some developments since skeleton arguments.
Oh.
So Schedule 2 to Ms. Jabala's 12th witness statement, which I'm going to call Jabala 12. Schedule 2, which is at 2589, which is a schedule to witness statement dated the 15th of October, sets out the defendant's evidence as to hits and alleged costs of review. Now that just set out the position on hits without providing detail in relation to searches and custodians. On the 20th of October 2025, 2667, the claimants requested information in relation to searches and custodians and so forth that underlay this figure.
Do you want me to go? Sorry to interrupt you. Do you want me to go to this correspondence now, or just take the references and review it later? Because I have a supplement 2 to the hearing bundle.
Yes.
Which came in very early this morning. I'm not sure exactly what time, but I've not had a chance to look at that yet.
Well, shall I take you? Let me take you to the absolutely key documents in relation to it, so that Your Honour knows where that documentation is and the position that has been reached between the parties. So if one started with Jabala 12, the reference for that is 2589.
I'm a page ahead of you. You understand? You know that, don't you?
I did. My heart rather sank when I saw an email suggesting that I think it's the good old index.
Yes. Don't worry. I'm capable of adding 1 to any number that you give me. So just so I'm clear,
Your Honour, scheduled. I have a schedule 2 at page 2589. Is that 2590 for you?
It's 2590 for me, yes.
Right. I'm grateful. If you wouldn't mind adding 1 to the references I give you.
No,
that
you
would-
just
that
you
would be
get.
very
I don't want either of you to be bothered. You've done it on the original bundle. This numbering's going awry by 1. Just give me the numbers and I'll add 1 from
I'm
your
very grateful.
notes.
I'm very grateful. So
I've been there, Mr. Hubble. I've been there many times.
well, I'm very grateful for your understanding. So what we are looking at here, just to trace this through, is the is an exhibit or schedule to the 12th witness statement of Ms. Jabala served on behalf of the defendants. And this is the, as it were, the origin or the evidential basis for the reference that you will have seen in a number of places in the defendant's skeleton argument, indeed in our skeleton argument, to the number of hits that particular searches are giving rise to. And if you look at, by way of example, the claimant's request 1, which now is in effect limited to drafts of engagement letters, and the claimant's request 2, which is documents relating to engagement letters, that's internal documentation to the defendants relating to the terms of engagement letters. What is said in fairly bald terms is, well, that gives rise, in relation to request 1, to 20,215 hits, including family documents, and in relation to request 2, 68,024 hits, and so on.
Just give me very briefly your definition of, quote, family documents.
My understanding of family documents means all attachments to emails. Yeah. Now, that, of course, can be a significant variant when one's looking at the burden of search terms. If you strip out, for instance, family documents, you can often dramatically reduce the number of hits, because you may be interested in the emails passing between, as an example, you may be interested in the emails passing between members of the audit team in relation to the AH audit, and it may be the email that really one's after, rather than the 10 attachments which are sent 10 times to 10 different people and result in 100 hits.
Very well.
But the point in terms of how developed the evidence is before the court is that what you have got here is just the number of hits, including family documents, without a breakdown of the underlying components of the search. Your Honour will know that at its absolute broadest, there will be issues as to date range and whether one can reduce date ranges. There'll be issues as to custodians and how many custodians there are. There'll be issues as to the search terms that we use. Were they very broad? Were they very targeted? And that will obviously have a dramatic impact on the number of hits. And that information did not come with Schedule 2 to Jabala 12. What came was the number of hits, their assessment of the number of hours it would take to review those documents, and then their assessment in AED of the cost of the exercise.
Yes.
So that was on the 15th. We sought further information. I don't think I need to take you to these documents, but let me give you the references. We sought further information on the 20th of October, 2667. On the 21st of October, Al Tamimi replied saying they weren't then able to produce the information, 2672. And then on Friday, the 24th of October, after exchange of skeletons, the defendants did provide some further information with a further schedule setting out search terms. And for that, you will have to go into you should have received 2 updates
Well, the first update was included in version 2 of the bundle, which is the one I'm working from principally. And
Yes.
I now have Hearing Bundle Update 2
Yes.
of the 27th of October, and I have that open. Also, the version 2 of the bundle. So take me to wherever you want me to go in either of those bundles. It will be in one or other of them.
I'm very grateful. The letter that was sent by Al Tamimi on the 24th of October 2025 is at 4079. And that addresses a number of the outstanding issues between the parties. But for present,
can you give me the one thing that's missing from the index to the second supplement is a digital page number. So what I have are the running
yes,
total bundle page number. So if you're looking at it in a separate,
I think it is. If you don't mind references being provided to me from stage left, as it were.
Not at all. Not at all. Grateful.
114
PDF.
of the PDF.
I'm there. I have it.
I hope should be page 4079. And if you were to scroll down to internal page numbering 4083,
yes,
you will find that what was provided on Friday early evening UK time, after or late afternoon UK time, after Exchange of Skeletons, we're starting to get some information in relation to the underlying searches. So if you looked at claimants request 1 engagement letters, it's identified the date range in the first column. It's identified the search terms used in the second column, and then the file types searched in the fourth column.
yes.
And that information has now been provided in relation to the requests that were previously the subject of Jabala 12 and the schedule.
So this is a much more detailed representation of Schedule 2.
Exactly.
Exactly. With the detail now inserted.
Exactly.
Which can be the subject of discussion and or refinement and or narrowing or whatever you may do.
Exactly. And let me make two observations in relation to that. One, this is making good my submission that the parties haven't had the opportunity, or let alone completed the process of liaising, hopefully constructively, with a view to identifying and narrowing date ranges, custodians, and search terms. And two, which in my submission is very likely to go a long way to addressing my learned friends' concerns in relation to the burden of production. And in relation to, there's a rather good example of that on page 4086.
Just whilst I'm turning up page 4, moving to 4086, this is a point that I had in mind when I asked the question at the outset about the form of order. Say, for example, I was with you on this. I've not made any decisions at all whatsoever. But if I was with you on this, what form of order do you seek? You may not want to give it me now, but what form of order do you seek that will contain sufficient direction to the parties, if I was with you, to narrow these search parameters that have been used here that will be effective, so that the parties are not constantly coming back to the court saying, oh, well, we wanted it restricted in this way, custodians, dates, whatever else in those parameters you might wish to adjust. What form of order would the court make to require the parties to come up with a search process that was proportionate, fair and proportionate, reasonable and proportionate, to get to the documents that are likely to be, I'm using your phrase now, there's reason to anticipate that will be relevant and material?
Well, Your Honour, if I may say so, that is an absolutely excellent question, and one which I've been grappling with. It seems to me that there are really only two ways to approach that. Mindful that on the one hand, there undoubtedly should be progress that the parties can make liaising, but on the other hand, frankly, one needs the focus of a court hearing and the possibility of Your Honour actually making a ruling to focus minds and to the extent necessary bang heads together. Either during the course of submissions today or perhaps revisiting tomorrow, the parties actually make submissions about what the form of search and search terms should be and date ranges and custodians at this hearing, rather, as I've been doing, I provide submissions that show what the nature of the issue is to Your Honour and indicate the likely progress that can be made. And then when Your Honour hands down, as it were, a preliminary or provisional decision or provisional determination in relation to the various of the requests, then at that consequentials hearing, if there are, or perhaps even more ideally, if Your Honour was able to hand down a decision in writing with essentially a red fern schedule saying yes or no as a preliminary determination, and the parties would then turn their mind to the searches and then come back for you in short order if they were unable to resolve matters between them. And then, if the parties can resolve the matter, they can agree to the terms. If there are outstanding issues in relation to custodian search terms, they can come back in a focused way for the court to rule on them.
Yes. Well,
and it may be that the latter approach is the better, because this aspect of the evidence, because of the on the one hand very positive speed with which the hearings have come on, but the nature of the correspondence, the speed with which these applications come on, is that, if I can put it colloquially, this aspect is a bit undercooked.
Yes, very well.
And can I give you an example of that? Which is, we were looking at page 4086 and claimant's request 12, which was KPMG presentations and updates. And as the footnote on that page makes clear, the figure for that was 176,975. Yeah, 176,975 hits. And it seems that with some slight reduction in search parameters, we don't know precisely what they were, but with some slight reduction in search parameters, that has dropped from Schedule 2 to Jabala 12 to 138,173 hits.
Yes.
Just whatever it may be, some minor adjustment, it seems.
I get your point. It doesn't take much in tweaking the search parameters to have a significant, or potentially have a significant reduction in the product, as it were.
Exactly.
The hits.
Exactly. And if just to conclude this, and we're getting, as it were, almost into real time. If you go to 4089, which is internal page 124. Yes, yesterday, those instructing me, Simmons and Simmons replied to Mimi in relation to various matters, including at paragraph 5, setting out various proposals that should significantly reduce the ambit of any search, including what's, for instance, at 5C on page 4090, that what has materialized is that there were 35 custodians being used, and our response is, well, actually, you can reduce 35 custodians to 12 custodians. And we anticipate that that will make a very significant difference. And the defendants, and then the Simmons and Simmons, by way of schedule to this letter at 4093. So if you were just to scroll down a bit further.
Yes.
You now see the schedule that was attached to Al Tamimi's letter of the 24th of October, with an additional column with the claimant's comments in red, aiming at identifying search terms that should significantly reduce the scope of hits.
So your position is that you're not just saying that the parties can get together and sort things out. The fact is that they are now getting together and trying to sort things out to reduce the number of hits and the burden of the request that you are seeking an order on, or the requests. You're getting there, to put it in the vernacular.
Yes, I anticipate that when my learned friend comes to his submissions, he may say, oh, well, this is all too late, or this is in some way that, the objection, of course, is maintained. But there has been correspondence just in the last Friday and Monday where the process has been started of engagement. And the example of engagement letters is a very good example. If you search for engagement letter, you may well get a huge number of returns. If you search for a phrase from an engagement letter in relation to audit work, you should get a dramatically smaller number of hits. Now, I'm giving you an example, and I'm conscious that if it's not an efficient use of the court's time, and frankly, we need a 5-day time estimate rather than a 2-day time estimate. I suspect if we were to work through for each of the requests, the points that have been made in this schedule, and for all I know, the defendants may have points they want to come back with. So that was why I've alluded to the possible. Of course, one could do that. One could just crunch the custodian's date ranges and search terms on this hearing, or as this snapshot has, I hope, shown to the court, that there is a process underway which has looks like it's making real progress. Although, of course, what we don't have is the defendants having plugged these suggestions into their document universe and coming back and saying, oh, well, instead of 20,000 hits, now it's only 5,000, or we haven't got that next stage in the evidential cycle.
No, I think, Mr. Huddle, what I ought to indicate at this stage, I don't believe it is an appropriate use of court time for the court to sit here for 2 or 5 days, whatever it might be, directing very, very competent lawyers as to how they should approach this task of trying to agree appropriate search parameters for documents. That's the first thing I need to indicate. The second thing is to indicate that I commend both parties. As we've just said, we are where we are. Whatever has gone before is water under the bridge so far as this exercise is concerned. And so I commend both parties, Altamimi for coming up with the goods, as it were, in the first place, of explaining what search terms they used, which has now enabled Simmons and Simmons to go back with these comments. This is a process that I commend the parties for adopting. And whichever way I decide on the orders, and understanding that the objections in principle are likely to be maintained, I can see that a form of order could be made if I did make an order for production that would result in the parties' engagement to get to a proportionate, reasonable and proportionate approach. That is not, I stress, not in any sense to indicate that I've made any decision on the making of any production order. But if I do, that is the way the parties should proceed to comply with any order I may make as to how the production should be performed. I hope that's helpful.
I'm grateful, Your Honour, and if I'm, as it were, well heard, I'm sure from both parties. So that was my fourth introductory point, which was search terms and where the parties have got to. My fifth and final introductory point is to explain that these present proceedings have not arisen in isolation, and what the consequences of that may well be for the defendant's ability to assemble and provide documentation. And that's because the collapse of the Abraaj Group was a very high-profile event, and it's already resulted in a material amount of both regulatory and civil proceedings.
I'm aware of all of that, yes.
And can I take you to 2 pages in the bundle to indicate the potential significance of that?
Yes.
And that is to the 6th witness statement of Kirsten Kitt from Simmons and Simmons, which is at 2653.
Yes.
So in the main bundle.
Which paragraph?
Can I take you to paragraph 12? And can I simply highlight as a helpful compendious place at paragraph 12 on 2656, it identifies the other proceedings, including relevantly for present purposes at 12A and 12B, regulatory investigations by the DFSA, culminating in a decision notice against the first defendant, KPMG Lower Gulf, and regulatory investigations by the DFSA culminating in a decision notice against Millens Navalka, who was the former audit partner from KPMG. And the significance of that issue is that the regulator, the DFSA, and this is way back in 2019, the first Article 80 notice was on the 9th of April 2019. Can I ask you to go to 2674?
Sorry, just give me that date again.
The 9th of April 2019.
Yes, and then the page again.
2674.
Thank you. Yes, I'm there.
So there were two of these notices in not identical but similar terms. This is the first one dated the 9th of April 2019. And this is essentially this is a notice from the regulator to the second defendant, asking for information to be provided in respect of an investigation into contraventions by KPMG LLP, first defendant, KPMG Lower Gulf, the second defendant, and any other KPMG entities. And then if you were to go to page 2678.
Yes. Schedule 1, specified information and documents.
Yes, and that sets out 6 categories of document, which, as we have explained at paragraph 14 of our skeleton argument, actually on the face of it would seem to map across to a considerable number of the requests that we now pursue. So paragraph 1, copies of versions of KPMG audit procedure manuals or guides relevant to the audit of the Abraaj group in place from 2011 onwards. For instance, that actually maps across to request 7H.
Yeah, for all practical purposes, Abraaj Group and Abraaj Holdings is the same entity.
Yes, well, I think you get that from this notice from paragraph 2.
Yes.
Please provide the following for where KPMG is or was appointed either as an external auditor or in any audit capacity of any entity within the Abraaj Group, including but not limited to AIML, Abraaj Holdings Limited, which is AH.
Right, I have it, yes.
So this notice, and that then seeks all the communications between KPMG and the Abraaj Group, copies of documents and reports which were produced by KPMG for on behalf of the Abraaj Group, including draft sets of financial statements, copies of documents collated or prepared by KPMG to conduct its work for on behalf of the Abraaj Group. So that, and which is on the face of it a group, an amount of material which requests for the AH audit files, request 7 D&E, communications associated with the AH audit files, request H, Mr. Darve, request 12, presentations, would seem to all be within that category. And then 2D, copies of any internal reviews into the quality of Abraaj Group audits would seem to map across to request 13. And then item 5, an account with supporting documentation explaining KPMG's understanding of the operations of AIML, and so on, would map across to one of the items in request 15. Now, what then happened is that there was a process of correspondence between Clyde & Co, who were then acting for KPMG, and the claimants, where consent was being sought for KPMG LG to provide documents relating to the audits to the regulator. For your note, there is a letter at 2698 of the 6th of August 2019 from Clyde & Co to Simmons & Simmons, attaching the 2 Article 80 notices, saying that KPMG would like to cooperate with DFSA to voluntarily disclose the documents sought and seeking confirmation of consent from Simmons and Simmons. And then if one goes over the page 2700, there is a consent is forthcoming on behalf here of AIML for KPMG LG to provide the documentation sought to the regulator. It's not conditional on provision of the information made to AIML, but a copy of the responsive documents is sought, although it was never provided by KPMG to AIML at the time. Now,
right, well, that was going to be my next question. Do we know if these notices to produce documents, which we've just looked at in this bundle, were they complied with?
We are not in a position to know, as the claimants, precisely what was provided, because we were being sought, our consent was being sought by this correspondence in relation to these notices, which were served on KPMG rather than us, rather than the claimants. So, but Clyde & Co contacted saying, we're saying on behalf of KPMG, to the effect that KPMG wanted to provide the material to the regulator. They wanted, for good order, to have our consent. We provided our consent and said we didn't want to stand in the way of the material being provided to the regulator. We asked for the responsive documents if we could have them, but they weren't provided to us. So I'm not in a position to tell you exactly what was provided. My submission is, well, I mean, first of all, none of this is surprising. This is a very high-profile collapse, and it is unsurprising that there should be notices served by the regulator. And the inference is that the materials were assembled, because that's the basis on which Clyde & Co wrote to Simmons and Simmons, and provided to the regulator. And indeed, we know that regulatory proceedings ensued and there were decision notices issued.
Well, yes, you do know that. And do you also, are you also aware of a negative fact? I was involved in another life in market regulation, so I do have some understanding of this outside the normal course of events. Were there no proceedings for a failure to comply with requests by a regulator to produce documents? Or should I put it in a positive way, were there any proceedings by the DFSA against any party for failing to cooperate with their investigation, failing to produce documents they were ordered to produce?
That's a very good point. The answer I'm going to give is I am not aware of any, but I'm sure that that can be checked so far as we're able to check it, and I can confirm the position if it's different. The regulatory enforcement proceedings brought against KPMG, LLP, and Mr. Navalka were certainly, they were defended, but you'll be aware the decision notices were made. I don't recall that a feature of that was, as it were, non-cooperation in relation to documents. They were defended on the merits, although unsuccessfully. So the inference I invite the court to draw is documentation either precisely overlapping with or very similar to a number of our requests, in all likelihood, has been assembled long time ago. Back, the process will have started back in 2019, and in all likelihood will have been reviewed. So it would seem to be an unnecessary reinvention of the wheel, if I can put it that way, for the defendants to say, we've got a document universe of 6 million documents. If we put in these fairly broad search terms, we get these enormous hits. This is all going to be an undue burden, because there's been a process that started back in 2019 of requests for documents, which seem to closely match with a number of the requests that we are raising, that in all likelihood we submit will have resulted in assembly and quite probably review. So there's a pretty readily apparent starting point in my submission for the assembly and review exercise which we've identified.
Thank you.
So those are my introductory overarching points. I was now going to turn to the requests themselves, and I'm going to deal first of all with request 4, and then I'm going to deal with request 7 D&E and request H, and these are requests that relate to the AH audit files and communications allied to that. Now,
sorry, I was just turning a page. So it's request 4, 7.
yes.
Just give me the list again that you're dealing with.
Well, I'm going to deal with request 4 in isolation.
Yes.
Then I'm going to come on and deal with request 7 D&E and request 8 because they're under a broadly similar umbrella, although they each fall to be considered on their own merits. Yes. And I was just going to direct your attention to our skeleton argument, because the positions are quite well rehearsed in both parties' skeleton arguments in relation to these specific requests. And for request H, which is the AH audit files for FY13 to FY17, this is addressed in the claimant's skeleton argument at paragraph 16 to 27, and the defendant's skeleton argument at paragraphs 52 to 59.
Thank you. I have, of course, read those with all references in depth and detail.
Well, that may well. I did say at some point I may be capable of speeding up a bit, and that may well assist the process, particularly if you've had the opportunity to follow some of the references through to the underlying audit files. So picking up the story at paragraph 16 of the claimant skeleton argument, request 4 is for the audit files of AH as distinct from AIML and ACLD, and I'll refer to those as the AH audit files. And AH, as I've explained, was the holding company of the Abraaj group, which owned AIML, which in turn owned ACLD, and AH was audited by KPMG LG for FY13 through to FY17. Now, my learned friend deals with request 4 together with requests 7 D and E, because in one sense they are allied requests. But actually it is important to consider request H for the audit files, the AH audit files, on its own, because the only issue in relation to request 4 and the AH audit files is one of relevance. And that's because, as Your Honour may well be aware, and albeit perhaps not as organised chronologically as nice as one might want, but what is apparent from the exhibits is audit files sit in a bespoke e-audit software package. And you may be familiar with that, we may have gleaned it from the exhibits. An audit file is not like sort of a barrister's old-fashioned set of papers or a solicitor's set of papers where documents are just sort of assembled together. An audit file has a software program with a whole series of sections and prompts and questions. And so the provision, for instance, of the audit file for AIML is, well, it's been provided as a PDF. It's a PDF printout from a software package.
Yeah, that's pretty obvious. I've looked at various things that I've been referred to in the documents. I've seen the tick box system.
Yes.
I've seen the product, the responses, yes, and so forth that
yes,
are entered into it. I'm aware of an issue, for example, about a mistaken entry in relation to one matter that you rely on. The defendants say yes, it was a mistake, and so on. So I've got a grasp of yeah, how these software files work.
The point I make, and it is in relation to the AH audit files, that the production of that material is really the click of a button, or a number of clicks of a button, if I can put it that way.
Yes, I have
because it, so really this is about relevance, and we submit that the AH audit files are plainly relevant. Indeed, they're likely to be highly relevant to the fair adjudication of these claims, as the AH audit files will likely be material to breach, causation and quantum. Conversely, as Your Honour will have picked up from skeleton arguments, the defendants submit that they're irrelevant. In particular, they say because AH isn't a party, and accordingly, the proceedings are not concerned with the audit of AH. And that's a key issue in relation to this request. So if I then turn to the question of relevance, and pick up the position at paragraph 21 of our skeleton argument, we say for a number of reasons that the AH audit files are likely to be relevant and material to the question of breach of duty. The defendant skeleton argues split out across what they describe as their first, second and fourth objections on relevance. But this is a audit negligence claim by these claimants alone, based on negligent failures, based on omissions by the defendants in their audits of these two companies alone. And that being so, the AH audit files are irrelevant. And we submit, by way of overview, that analysis is wrong and ignores the realities of group audits and the realities of the defendant's own audit files for AIML and ACLD. In short, we say, in order for the court and the claimants to have a complete picture as to what the defendants did or did not know and what audit work they did or did not do, it's necessary to have the AH audit files as well. And there's no particular surprise in relation to that, because this is a group audit and AH produced consolidated accounts that covered the financial performance of AIML. And from the audit files that we do have for AIML and ACLD, it's apparent that important audit procedures, if they were undertaken at all, appear to have been undertaken at the AH group level. And so to make that good, the first point which we develop at paragraph 21 of our skeleton argument is that the AIML ACLD audit files and the AH audit file are clearly interrelated. And you will have picked up from the evidence that the fourth witness statement of Kirsten Kitt set out 11 non-exhaustive examples of that interrelatedness, which at its most simple is where the AIML or ACLD audit files cross-refer to the AH audit files or refer to audit procedures or audit work that was done at the AH group level. And so at its most simple level, you need to have access to the AH files in order to understand the AH audit files, in order to understand and see in its context the audit work done on the AIML and ACLD audit files.
These are the particulars you're referring to at paragraph 61 of her statement.
Exactly.
A to whatever it is, scrolling down.
A to K, I think it is.
A to K.
Yes. And the big picture is there are 10 or 11 examples of where the AIML and ACLD audit files appear on their face to refer to or rely on audit work or audit procedures undertaken at group level. And if you're dealing with testing or planning or going concern, you need to understand the work that's been done by the auditors. And if the audit files refer to work done at the consolidation level or at the group level, then that's a hole in understanding what they did or didn't do. And that and the essential point is we've put forward 10 or 11 examples. We've had a partial response, which we don't regard as adequate in Jabala 12 to 3 of them only. But the underlying point remains sound. I'm conscious of the time, but I would like to take you to some of these examples just to illustrate and make good the point.
Yes, certainly. Time-wise, we've not, as it were, had a hearing timetable. There hasn't been time for a timetable. But roughly, how long do you think you'll be? Are you going to take the whole of today and Mr. Smith the whole of tomorrow, or and there's an issue of reply and so forth? Do you want to give some thought to it between yourselves at a break?
Yes.
But just carry on for the moment.
Yes,
I don't want to waste any time.
It's certainly likely that I'm going to be the majority and possibly all of today.
Very well.
But that's assuming we're operating I think it's a 6-hour court day with a 1-hour break.
Yes.
But
I'm going to break shortly before what is 9 o'clock in the UK and 1 o'clock in the DIFC. I have a matter actually I have to attend to both today and tomorrow in that break, short matter. So at a convenient moment, approaching 9 o'clock in England, I presume you're in England, are you, Mr. Hubble?
I am.
Yeah, same as myself at the moment. Right, so carry on. You were going to take me to something that you want me to look at.
I was going to take you to. I don't want to get, as it were, totally lost in the weeds of the audit files, but I was going to take you to some examples to make good the point.
Yes.
That there is a interrelation between the AIML and ACLD audit files and the AH audit file in support of the fundamental proposition that if you want to understand the audit work that was done for good or ill, you're going to need to see the AH audit files as well. And I'm picking up the example that is in fact addressed at our paragraph 21A of our skeleton argument. And that relates to related party transactions within the FY16 year. And for that, can I invite you to go to page 1000 and
2 or 3 for me.
Yes, three for you.
Yeah, I've looked at this.
Yes.
Yeah,
so
draw my attention to what you want me to look at particularly.
Yes. Taking the numbers for the accounts on the left-hand side, the first row, 12100. This is related parties. You understand there were very large sums that were said to be owing to or from in relation to related parties. Due from AH Group companies, 1.124 billion. That's a variation from the year before of 42.7 million, if one reads across. Please note that this amount will be fully eliminated at consolidation level. No further investigation, as it will be tested through our consolidation file.
And consolidation file is...
we understand that to be a reference to the AH file or work at AH Group level. Because that's, as we understand it, why it's going to be fully eliminated. And the same note applies in relation to 22,100 due to AH Group. So due to rather than due from, there's a variation from the previous year of 27.44 million, and one sees the same note.
Yes.
Then this is example B, is staying on related parties, related party balances that are analysed on the AH audit file. And let me give you an example of that, which is at the FY13.
FY13 or 14?
Yeah. This is FY13. This is actually a reference that you may not have seen because we were following this through. This is FY13 at 1385.
No, I've not seen this one.
I think you will have you will have seen the generic. If you follow the references, you will have seen the generic audit procedure that refers to obtaining a list detailing the nature of related party relationships. But if you then go on to 1385 and FY13, about 4/5 of the way down the page, you'll see procedure details.
Yes.
Detailed description of procedure. Inquire the nature of the related party balances. Refer to AH Consolidated Analytical Review. Did you see that in brackets?
Just give me a moment. No, I'm not. So I'm looking at the moment on page 1385. Should I be looking on 1386?
Well, it's my 1385.
Ah, there it is. Yes, sorry. So
there's
inquire the nature of related party balances. Refer to AH Consolidated Analytical Review. I have that. Yes.
So it's a similar point.
So at the top, just above it, the location in the audit file that I'm concerned with is the heading receivable from partner companies due to ACHL, other receivables and so on. That's, as it were, sets the scene or the ground that they're working with.
Yes, but and also the procedure details, which is important. Inquire the nature of the related party balances. That means look at what's owed to a related party and what's owed from a related party. And related party is an important feature of this litigation.
And saying that will be found in the AH Consolidated Analytical Review.
Yes. Then I think this is an example C, which is testing of internal controls.
Forgive me. Sorry. Could you go back there?
Yes, yes, of course.
Cardinal Sin did not turn off the phone. I'll find myself for contempt.
And then example C, again from Miss Kitt's witness statement, which is testing of internal controls environment undertaken at group level.
Yes.
Now this is one where you've been directed, you were just directed, not as helpfully perhaps as we might have been for you, to the whole of the audit file for FY16. This is showing the testing of internal controls environment. What we have done is added the work paper, which is being referred to and which Ms. Jabala refers to, because she does respond on this example in her witness statement. And that work paper is at 3988 now in the bundle, which it's the first updated.
It's at page 23.
If you're in updates, it's page 23. If you got a
No, I'm in updates. 23, you say? Yes.
yes.
Ah,
It should be page 3988.
3988 I'm looking at, and it's headed Client Abraaj Capital, prepared by Chitra Jamtani.
Yes.
Objective to ensure the audit process is conducted in accordance with ISA 200. Overall objectives of the independent auditor and conduct of the audit.
And then if you see work done,
Yes.
and then the penultimate entry,
Yes,
tested controls and evaluated the control environment undertaken during the group audit to ensure internal controls are effective and there is no override of controls by management.
this is. Sorry, I'm just making a note of the page number. Thank you.
And can I just pause for a moment and emphasize the significance of that entry? Because to be colloquial and to boil down what will be a matter for no doubt intense scrutiny at trial, part of this case is that Mr. Nakvi, the dominant figure, as it were, in the executive management at Abraaj, what was using funds rather as if it was his own piggy bank and involving himself and others in window dressing transactions at year end and shifting money around without proper regard for appropriate governance. And that, of course, is one quite common form of fraud. It's fraud by management. And so ensuring that you've tested the internal controls are effective and there is no override of those internal controls by management is directly relevant to what is likely to be a very clear focus at trial.
Very well.
And the point is, what's being said is those internal controls for the group organisation were tested at group level. So
right. Well, I have that point now.
Yes.
Clearly. Would that be a convenient moment?
Absolutely.
For us to adjourn, and we'll resume at 2 o'clock in the DIFC and at 10 o'clock. As I say, I have a short matter to attend to. I don't believe for a minute it will go beyond the due start time. But if you do not see me on the screen, I'm just finishing something off. I certainly shan't detain you long. Right, we leave it there for now, and thank you very much so far.
Thank you very much. Thank you very much, Sean.
Good afternoon, everybody in Dubai. Good morning again. Morning again to all in the UK.
Good afternoon.
Right. Are we ready to proceed? Everybody, I think, is switched on. Yes. Good. So, Mr. Hubble, we were just looking at
some examples.
Yeah, 3988.
Yes.
is my last note, and I think you'd completed on that.
Yes, and I was going to take you, please, to example D from Kirsten Kitt's list, which is at 1847, which is to a work paper from the FY14 audit file in relation to AIML.
Yes, I've looked at this one, highlighted it, and annotated it. Paragraphs 1, 2, and 3 in particular at the bottom.
And if I can just tease out that what I say is the particularly significant point.
Yes.
There's also a fundamental issue when you're the auditor and you're auditing accounts as to whether those accounts are prepared on the going concern basis, i.e. it's a viable business that one can anticipate is going to trade for a foreseeable period. And the going concern and the going concern issue is pleaded at present in the re-amended particulars of claim. I'll just give you the references at
yes.
Paragraphs 15.7.3.1, which is page 3797, and 51.4 at 3822. But it's fair to say it's pleaded in significantly more detail in relation to the draft third particulars of claim, including a positive proposed case to the effect that the work in relation to going concern for AIML and ACLD was inadequate, and that the accounts should or may well not have been capable of being prepared on the going concern basis. And
where is that in the TAPOC?
In the TAPOC, I can take you to it, or I can give you the paragraph references, whichever is most easy for you.
Yeah, take me to it quickly. I can navigate this fairly quickly.
Yes. Okay. In which case 303 paragraph 50H.
Yes, I have it.
Is the plea in relation to AML, pleaded breaches in relation to AML as a going concern for each audit year, and by reference to AIML's history of substantial losses, as well as a failure to establish AH's intention and capacity to provide further funding. So one sees that at page 303 under the heading breaches in relation to AIML going concern.
Yes.
And that is developed and pleaded out in some detail throughout the particulars of 50H, the subparagraphs at point 1, which is a failing to identify and understand or reflect upon the implications of the level of losses suffered by AML. At 50.2, insist on receiving sufficient audit evidence, including appropriate forward projections for AIML and AH. So you'll see that AH is positively pleaded, because of course AH is the parent company, and you've seen, and it's referred to, I think, in this note, that there was support in a very large amount of some 49.95 million. And then 50H.3 seeks, should have sought to establish AH's intentions relating to whether it would continue to provide AML with funding, whether there are any conditions that needed to be met for that funding to continue to be available, and AH's capacity to be able to provide such funding. Because the basis on which, as I understand it, when one reads this note, the defendants concluded that it was appropriate to audit AIML as a going concern, included the proposition that it was going to have support from AH, and the defendants in their audit of AH had concluded that AH accounts should be addressed on and dealt with on the going concern basis. That's what you get out of paragraph 2 on page 1847 we have assessed the going concern assumption for Abraaj Holdings and found the parent company to be a going concern as well. That must be a reference to the audit work done at group level.
I think I've annotated that. Just give me 1 second to check.
So it's that sentence further. We have assessed the going concern assumption for Abraaj Holdings, not AIML, for Abraaj Holdings, and found the parent company to be a going concern as well. i.e., the audit work, presumably, that must be found on the AH audit file, which is the basis on which it is concluded that AH is a going concern, which is relevant to the preparation of AH's accounts, but of course fundamental to the going concern assumption for AIML because it's dependent upon financial support from AH. And 50, sorry to be leaping around, but back at page 304, 50, paragraph 50I sets out what the reasonably competent auditor would have done in relation to going concern, linking it to the broader causation case. And so the steps that the reasonably competent auditor should have taken in relation to going concern.
Part of your counterfactual.
Exactly. And there are similar paragraphs. I don't think I need to take you to them in relation to ACLD at 55E and 55H.
Just give me the page references.
Yes, 55E, page 317, 55H, page 318. And then at 61.5, at 324, that also follows through to an amendment at 61.5. So we're now, when I showed you paragraph 50I, that was, as it were, a linking causation plea at the end of the proposed pleas in relation to breach, in relation to going concern. Paragraphs 60 and 61 are the substantive plea in relation to causation. And at 61.5, in any event, KPMG LLP would have sought clarification from AH/AIML, ACLD's legal advisors and or their own legal advisors, and then reported to DFSA the irregularities and other matters identified above, including as to going concern.
Well,
and so the point is that so far as we can tell, the relevant audit work, if it was done, in relation to partly the correct assessment of AIML as a going concern, but also the apparent reliance on AH as a going concern, is all going to be on the AH audit file. So that's going concern. Example E, which is evidence in relation to risk assessment and planning discussions for AIML in FY13. It is at page 1320.
sorry, I was just finishing a note. Sorry, what was that last page number?
1320, please.
Yes.
We're now moving to FY13 and to if one looks at the top of this page at 2 Do you see the number 2.14.1?
I do. Risk assessment and
risk
planning.
assessment. So this is the stage, an earlier stage in the audit cycle, where the audit team are carrying out their risk assessment, or should be carrying out their risk assessment, so that they can identify risks for the audit, which they can then tailor their audit procedures to meet. And so it's an early stage in the process. You have your risk assessment and planning discussion, and then audit procedures will be varied or designed to reflect it, or should be.
And this is in which company?
This is AIML.
AIML. Right. Thank you.
And then if we go down to further on towards the bottom of the page, there's an entry, matters to be communicated.
Yes, I have that.
For those team members and other engagement reviewers that were not involved in the discussion, we communicated the following matters. And then the entry there, refer Abraaj Holdings e-audit file section 2.14.1.
Right. So that's a direct reference.
So as we understand what we think that represents, it's saying for other team members who weren't in the discussion about planning and risk assessment, go and look at the equivalent paragraph and section in the AH audit file. And there, inferentially, you will find the information about risk assessment and planning. That's obviously, risk assessment and planning is a very important feature of the audit cycle. Again, we suggest that these examples I'm showing you are examples of, frankly, what necessarily isn't really very surprising, which is when there's a group audit and then there's an audit of subsidiaries within it, the planning discussion for the group audits about the risks that are being faced by the group or individual companies within it, it may be the case that is held once, but for the group as a whole, and it's recorded. On the face of it, it looks like it's recorded on the AH group audit file, but it's difficult to see how the court can properly and fairly assess the nature of the audit work done by the defendants in relation to AIML and ACLD in respect of risk assessment and planning, if what the audit file tells us, the audit files we have tell us, is go and look at the AH group file, and we don't have them. Example, there's a further example in relation to EQCRs. I'm going to pick that up later on, if I may.
Yes.
EQCRs, you want to stand for engagement control and quality review, and sometimes it stands for engagement control and quality reviewer. One way of thinking about that is it's like a second partner review. And there is very considerable confusion about whether there should or should not, on the face of the audit files, have been an EQCR in relation to AIML and ACLD. The audit files in various places indicate that there should have been an EQCR. The response from the defendants is those are all mistaken ticking of boxes and references. The EQCR was done at the AH group level.
That's what I was referring to earlier, the mistake point.
The mistake. And it's also said, I should say, well, there isn't a pleaded allegation in this case that there should have been an EQCR and there wasn't. Therefore, what's the relevance of all of this? But the relevance of all of this is much more fundamental, is that the court is going to need to understand the audit work that was done or not done and where it was done in order to form a view about the audit work done in relation to these particular audits. They've got to be seen in context. But I'll be taking you to the paragraph of our skeleton. It's in due course, which is paragraph 47 of our skeleton, which draws those references together in relation to a different request.
Yes, well, we'll come to that.
We'll come to that. Example G, communications with those charged with governance for the FY13 year AIML audit is at page 1274.
Yes, I'm there.
And that is 2.5.1 minutes, document review of minutes, including minutes of meetings of owners, management, and those charged with governance, including any relevant committees of these groups. And those charged with governance is an important term and an important potential issue, Ronna, particularly when one comes to causation, because those charged with governance means those individuals to whom the auditors would need to make a report if a serious issue arises, and would extend, for instance, to potentially the board of directors of AH in respect of a problem identified on an audit of AIML. So those charged with governance involves going above the executive management.
And would include non-executive directors, would it?
Exactly. And you can readily imagine that it is likely that at trial there will be evidence from, I'm going to put it in colloquial terms, innocent non-executive directors at AH board level saying, if these problems had been brought to me, I would have done X, Y, and Z. And one can anticipate that that will be evidence that will be led by the claimants and no doubt challenged by the defendants. But so that's the sort of backdrop to why this sort of aspect is potentially very important. But for immediate purposes, the entry beneath this is, for minutes of meeting, please refer to the Abraaj Holdings e-audit file.
So even you would say, presumably, even the dramatis personae at those recorded in those minutes who was present is material.
Yes, I'm not aware that these minutes feature in the production that we have received to date. They don't feature on the audit file, and I'm not aware that they feature in the wider pool of documentation that's being provided. So if you want to know what's it really operates at two levels. At its most basic, and this is a sort of fundamental proposition I advance. If you want to understand the AIML and ACLD audit files and understand the work that was done or not done, so the experts can deal with those issues, so the court can form a view about it at trial, you're going to need to see the AH audit file as well.
I'm just looking down to 2.5.2 inquiries. There we see again those charged with governance agenda. And we actually have some names then. Document the individuals interviewed below. Milind Navalkar, obviously. But what about the others? Samiuddin Siddiqui, Zainab Hafiz, and Ashish Dave. Do I pronounce that Dave or Dave?
My understanding is it's Dave.
Yes, I've encountered the name before.
Yes.
So yes, and of course we're going to come to him in another request, are we
Yes,
not?
but here's an example, because we're in FY13, of Mr. Darve on the Abraaj side of the fence,
Yes.
because he's being interviewed
As the CFO.
as the CFO.
Right.
So my first point is really a practical and pragmatic one, which is to understand these audit files. You can't view them in isolation. You can't divorce them from the AH audit files. That's the first practical point. So if you're going to assess what the knowledge was or wasn't of the auditors, what the work was or wasn't that was done, it would appear apparent that needs to be done in the context of the AH audit file as well. And then there are more specific points in relation to what are going to be key parts of the case, like planning, reports to those charged with governance, going concern, where the examples I've shown you suggest that if there is relevant material, or if there was relevant work done, it was done or is to be found, it's going to be found anywhere at the AH group level.
Very well.
And then the final example from this run I was going to take you to was Ms. Kitt's example K, which is information risk management audits for FY14, which is at 1589, and there's a similar reference at 1637. So if you we're looking at page 1589, we're looking at the AIML audit year for FY14, and it is here dealing with control test work, and at K you'll see the entry which is towards the foot of the page, document one.
Sorry, let me locate myself. I'm on 1589.
Yep.
And then on to 1590 on mine. The heading is 1.22 scaling.
Yes, and then if you scroll down,
yes, document,
about halfway down, you'll see scaling control test work.
Yes,
which is to do with the testing and effectiveness of controls, and then scaling involving others. And then at K, there is an entry that says document why IRM will not be involved, attach the agreement of the IRM specialist. IRM stands for Information Risk Management.
So let me make a note of that on the document itself.
And the entry, this is a specialized industry having few transactions of complex nature instead of common transaction of higher quantum. Transactions are unique in their forms, contracts, consideration. Therefore, an IRM test may not be an appropriate option due to the significance of the transactions under review. During the year, the company has introduced a new Oracle system to automate the consolidation process. This will be tested at the group level, Abraaj Holdings, by the IRM team, and work done by IRM is documented in the Abraaj Holdings workbook. So you've got a new Oracle system, a new finance system with automated consolidation of finances between group entities, as we understand it, is what that means. And it's being said, in essence, well, that's being tested by IRM at group level, and the work done by IRM is documented in the Abraaj Holdings, so that's the AH workbook. I infer that is a reference to necessarily the AH audit file. So information risk management is a form of testing of controls. There's a new finance system. It's not being done on this file because it's been done on the AH audit file. And I should say there are similar entries. I'll just give you the references for FY15. There's a similar entry at 1047, and FY16 there is a similar entry at 801. So having just in relation to these examples, having shown you some of those non-exhaustive examples, what they show, unsurprisingly, is the interrelated nature of the audit and the audit files for the parent company and the subsidiaries. And in order to properly understand what, if any, audit work was done on key issues such as planning, internal controls, and going concern, it's apparent that there is material that is, or certainly should be, on the AH audit files. There are two other points of evidence in relation to the AH audit files, which I just wanted to briefly develop before you. The first relates to some emails that illustrate the interrelatedness of the AH audit file with those for AIML and ACLD in relation to client evaluation and acceptance procedures. And that is a short run of emails that commences, please, at 2702.
Yes. Yes, I've read these.
Well, thank you. I'm grateful. We'll be able to take them quickly. 2702, starting at the bottom of the page and reading up. Can you please provide me with client acceptance for AIML? As such, we don't have separate AIML client acceptance as it gets covered at the holdings company, i.e. Abraaj Holdings. Let me know if you need AH client acceptance. So the client acceptance and evaluation process is dealt with at group level. There is a similar request in relation to ACLD at 2074 to 5. At the top of page 2705, Chitra Jamtani asks, can you please send me the client evaluation if it's done? And gets a short and no nonsense reply, no. And then Ms. Jamantani tries again. Could you please send me the client evaluation for ACLD to be replaced in the e-audit file? Can't. Discuss with risk. Let's go with AH this year. Next year, let's remember to do it at the beginning of the engagement. So again,
this is ACLD.
This is ACLD, yes.
And that corresponds, you say, to the AMIL references you gave me a moment ago.
Yes, exactly. So what it's really is reinforcing the same point in relation to for important processes, client evaluation and take on an assessment. It seems to be being done at the AH audit level.
Right.
And then finally, in terms of the evidence, and I can do this by reference to our skeleton argument, but if I take you to paragraph 26 of our skeleton argument, of the claimant skeleton argument.
26, just give me a second. Yes, I have it.
Now, the position, as I understand it, the position seems to be based on the evidence of Ms. Kitt at paragraph 62 of her fourth witness statement, which is at 464 and then paragraph 33 of Jabala 12, which is at 2575, is that the defendants have occasionally provided documents relating to the AH file insofar as they also relate to the AIML and ACLD audits. And we have identified or found 6 examples of that, although we are unable to work out and understand why we have been provided with those 6 and not others. And it's not entirely clear, but it seems to be the position that the defendants are saying that not that these are AH audit working papers from the time that were already embedded in the AIML audit files, rather they're separate productions by way of supplement to the AIML audit file taken from the AH group file as part of the production process. I should say it's not completely clear to me which of the two it is. But either way, it's significant as it amounts to an acceptance that there are, even on the defendant's case, audit work papers on the AH audit files that are relevant and material to the claimant's case. But they seem to us to have been provided on a rather ad hoc or random basis. And the answer is not to have some form of unsupervised and unclear process whereby the defendants alight upon certain limited work papers that they would like to produce from the AH files. The answer is simply to provide the AH files themselves, and I've given you the various examples that go to support that proposition. The defendants at paragraphs 57.1 to 57.2 of their skeleton argument raise various responses or objections based on an alleged lack of specificity in relation to examples given. Well, I hope my submissions have dealt with that, and what one might call pleading arguments about exactly what has or hasn't been pleaded in the case and whether this is a case of omission or not. Our answers in short form to those objections are the examples and emails we provided to you are non-exhaustive, but they give the court a flavour, good flavour, we say, that the court will only be best placed to properly understand the work that the defendants did or did not do in relation to AIML and ACLD if it has the AH audit files before the court as well. And there's every reason on what I've shown you to believe that there will be relevant and material documentation on those files in relation to breach of duty. And the defendant seems to suggest that because the claimant's case is based on failures by the defendants, that somehow means that the court doesn't need to consider what the defendant's actual knowledge was or should have been. We don't follow the logic of that proposition. The claimant's case is the defendant auditors failed in a number of respects to undertake the work and take the steps that they should have done. Now, whether it's you failed to take a step or you took a wrong step, whichever of those two situations, whether the sin is one of omission or commission, the starting point is the same, which is what audit work did the auditors do or not do? What was their knowledge? What should have been their knowledge? And that's the same. And it in our submission, it's a restrictive and somewhat illogical submission to say, because this case involves an assertion that the defendants failed to take various steps, you don't need to know what happened across the piece. It's also been said, well, the claimants have been able to plead out a detailed third amended particulars of claim by reference to the AIML files and the ACLD audit files. Well, that's true. We've done that on the material we've provided. But firstly, that obviously doesn't mean that no further documents are required. It means we've pleaded out our case and we've supplemented it by reference to the material that we've been provided with. That's then the basis, or it may become the basis upon which the court progresses matters and considers questions of production. But it doesn't mean you've been able to plead a case, therefore you don't need any documents. That's the wrong way around.
Especially where there's multiple reservations of a right to plead further upon further disclosure.
Well, Your Honour, the exchange that both advocates had with you this morning rather makes that point. We, keen to try and be efficient and move the case on, have provided draft amendments by reference to what we have been provided with, but necessarily we've got outstanding requests for production.
I've got to give you an opportunity to deal with this, Mr. Hubble. I am very concerned. I made it plain at the outset, but listening to your submissions, it becomes even plainer. If I do order substantial further production, it's looking inevitable that there will be further rounds, or at least a round of amendments that will be required to the pleadings in this case. And it would be very dangerous, would it not, for me to hold to a very tight timetable, foreshortened by 3 months because of difficulties. I'm not blaming anybody in disclosure thus far. If the inevitability is that there are going to be disruptions to it, so we hold on to a trial date for now, only to find it scuppered a few months down the track.
Yes, our position is we are very keen to keep the trial date if we possibly can.
I know you are, as was I, and certainly that was my first impression, my first duty to preserve and maintain a trial date. But if the reality is, and what you're pressing me to make orders for, without making any decisions at all so far, but in a cogent manner, and of course I will hear the respondents, the defendants' submissions in response shortly, all of that increases my concern that I may make production orders that will lead to a further round of amendments and a wasted effort, if I can put it that way, in maintaining a trial date that's not going to be realistically and fairly and justly, most importantly, attainable.
Well, I think the position in relation to that is one may just have to see how we go in relation to the application of the consequences. If the trial can be, we're a year away from trial. If the trial can be kept, in my submission, it certainly should be. If the production can be dealt with within a sensible time frame and amendments can be dealt with within a sensible time frame, we submit that the trial can still be effective. We do understand the point that a time will come when the burden may simply be too great for the parties and indeed the court, and one doesn't want a late adjournment of a trial date because of all the cost and disruption that's associated with that. But in relation to the AH files, we're back to my suggestion, which is actually they could be provided by the end of this week.
Click of a button or two, I know.
My click of a button point. Now that doesn't necessarily apply in relation to all categories, and there might even come a time at which the claimants have to cut their cloth in order to keep the trial date. But for those categories of material that are either in the click of the button category or have already been assembled and provided pursuant to the Article 80 notices, it would seem that they can be dealt with pretty swiftly.
Very well. I just wanted to give you an opportunity to deal with that. And so that you
Yes.
can appreciate that one set of your submissions are countervailing against the other set about maintaining the trial date to a degree. And obviously I'll consider everything
Yes.
you've said about this being manageable within the existing or slightly modified timetable you're now proposing. So
Yes.
I'm sorry if I've broken your thread.
No. It's an important practical point.
Yes.
Your Honour. I was simply going to draw together some and make very brief submissions. I've been focusing on breach of duty to date in relation to the AH audit files.
Yes.
And but there is also a question in relation to the issues of causation and quantum, whether material on the AH audit files are likely to be sufficiently relevant and material to those issues. And in our submission, they are likely to be relevant to those issues because the true financial position of AH and the true value of AH's covenants and ability to support AIML and ACLD is likely to be directly relevant to what reports should have been made by the defendant to those charged with governance, what those charged with governance would have done, and what counterfactual then applies. That is it a restructure and solvent trading scenario, or is it a insolvent, an earlier and more orderly insolvency scenario? And of course, there are financial statements that exist for AH, but there is very likely to be material on the AH audit files that bear on the underlying and indeed the true underlying financial position of AH. And indeed, the defendants appear to accept as much at paragraph 56.2 of their skeleton argument. They seem to accept that there will be some relevant or material documents in the AH audit file, but the suggestion seems to be that the claimant's quantum expert should identify those documents and then ask for them. But in our submission, that's really the wrong way round. The claimant's expert can't know what the precise financial information is that is on or not on the AH audit file, though can anticipate that there is likely to be relevant and material information. And we've given the examples in relation to going concern and so forth, where one would readily expect the financial information to be there. But the answer is, this is another reason why the AH audit files are relevant, and for them then to be produced rather than to try and make the claimant's expert play a game of battleships and put forward categories of documentation that might or might not be on the AH audit file. So for all those reasons, we say that the AH audit files are plainly of sufficient relevance or materiality, and there's no other ground of objection raised or which could be raised. In particular, as is confirmed in the evidence, AH consents to the process. There's no separate confidentiality issue raised by AH. So so those are my submissions in relation to request 4, which is the AH audit files. I'm now going to deal, hopefully more swiftly, because you will have the landscape, with requests 7D and E and request 8.
Yes.
And it might be useful, I don't know if you have them in separate hard copy, but it might be useful to have the red pen schedule at your elbow as a ready reckoner.
It is at my elbow, and I'm turning the pages of it as you speak, and I have the bundle on screen, so you can proceed.
That's very helpful. Because when I go through, I'm going to try and sort of distill down what actually matters, what's in dispute from the parties in relation to it. But it's important to have in mind what the actual request is, of course. Now, request D and E, which we deal with at paragraph 34 of our skeleton argument, in addition to the Redfern schedule, are aimed at capturing relevant documents within the defendants relating to the audit of AH. So we've got the AH audit files, which is request 4, and then you've got surrounding and ancillary documents arising from communications between members of the audit team, or communications between members of the audit team and others within the defendants. So the by way of example, in round terms, I think there's some I think it's something like 6,300 odd documents that have been provided by the defendants in relation to AIML and ACLD, and some 2,000 odd of those are additional documents that relate to the audit that sit alongside the AH audit files. And you've seen how the AH audit files work. They're, as you say, they're quite tick box. So request 7D is aimed at communications or documents within the defendant's audit team relating to the AH audit. And request 7E is aimed at communication between the defendant's audit team and other individuals within the defendants, including Mr. Darve, at the relevant time. So the aim is to capture relevant documents, relevant in particular to the AH audit, which are not on the AH audit files. And this is against the backdrop where certainly the claimant's analysis in relation to the AIML and the ACLD audit files that have been provided is that they do seem to be incomplete, and there is a process of having to fill the gaps from other communications and documents that have been disclosed alongside those audit files.
Sorry, you're saying the claimant's audit files?
Sorry,
seem to be.
Sorry, if I did, that was a mistake. Defendants' audit files.
Defendants.
Well, I was drawing the point of saying the AH audit files will be a important resource, of course, and go to and are relevant to material, but as has been found or shown in relation to the audit files we do have, AIML and ACLD, there is material that goes alongside it in terms of email exchanges, accompanying notes and documents, and this request 7D and E is aimed at that category of documentation in relation to the AH audit files.
So collateral documents might want.
You might call them collateral documents. Yeah. And if the court is minded to order production pursuant to request for the AH audit files, then we would suggest the same underlying logic would establish the relevance or materiality of those categories or communications covered by requests 7D and E. However, it is important to note that a burden of production point is taken in relation to requests 7D and E, which is not taken, can't be taken in respect of request 4 and the AH audit files.
Yes. Well,
so
I'm very conscious of that.
So it is if we get to a stage where we're grappling about trying to keep this case on track and get it to trial in October 2026, there may be a material difference between the request 4 audit files potentially and requests 7D and E. We suggest that the answer here, much as the exchange that we had this morning, Your Honour, is by cooperation and liaison and refined search terms is where the answer to this is likely to end up. We are not after communications in relation to every subsidiary within the Abraaj group. We're we're after communications insofar as they relate to AIML, ACLD, and AH itself. The defendants have provided an estimate of 56,000 hits, but you'll remember how I've taken you through those schedules at some pace, but I took you through those schedules that show that that was the start of the process. And since then, there's been exchanges of information and proposals made that may well have or are likely to have the effect of reducing the amount of those search terms. Certainly the amount of hits that are generated. So the claimant's hits in relation to this seem to have come down from at one stage an initial estimate 250,000 to 56,000. And in the most recent schedule that we have provided yesterday, we've postulated narrowing the database of information by using search terms or custodians by reference to 12 key individuals, using the word audit as a further exclusionary term, limiting the time periods, and so on. So the 56,000 is rather a counsel of despair, and the process of liaison that has been started, as you indicated this morning, if the court was to reach the view that in principle these are requests that meet the threshold, then one would turn one's attention to trying to narrow those searches in a way that really does reduce the hits. And if there's some cutting of cloth that the claimants have to make to keep the trial date, then claimants will have to cut their cloth, because that's a very important factor for the claimants. I also make the point, I don't want to rehearse it, but you'll recall the schedule to the first Article 80 notice from the 3rd of April 2019 that actually identified, by reference to AH as well, broad categories of document that would certainly capture these emails and communications. The page reference, should you want to go back to it at any stage, is 2678.
Thank you.
So again, we remain to be convinced that the defendants are really starting from scratch in relation to this material, because it's been assembled, or something like it has been assembled previously. Request 8, which has a date range of the 1st of October 2014 to the 28th of February 2017, is in relation to Mr. Darve, and you'll see that if you turn over a couple of further pages in the Redfern schedule. Now, we deal with Mr. Darve at paragraph 38 of our skeleton argument, and Mr. Darve is in a unusual and quite specific position, in that he previously worked for both the Abraaj Group and the defendants, and indeed we saw the reference in the audit file to him in his capacity as CFO. So Mr. Darve was the audit partner, the defendant's audit partner for the Abraaj Group from 2005 to 2007. From 2008 to 2013, he was the CFO of the Abraaj Group. So he swapped sides. Then from November 2014 to January 2017, he returned to the defendants, but it seems not in their audit team. And then February 2017, he rejoined Abraaj Group as the CFO. And we understand that Mr. Darve is presently facing extradition to the United States on fraud charges following his arrest in July 2025, arising from...
And that was in Dubai, was it?
Yes, that's my understanding. And in relation to his role at the Abraaj Group. And the multiplicity of roles of Mr. Darve as between auditor and audit client is a matter specifically relied upon by the claimants in support of a plea that the defendants failed to maintain independence from the Abraaj group and maintain professional skepticism. And the page reference for that is page 290 and paragraph 48.1 of the re-amended particulars of claim. So it's pleaded there that the defendants failed to maintain independence from the Abraaj group and an appropriate attitude of professional skepticism in particular, and then 48.1 pleads out the position in relation to Mr. Darby. The defendants pleaded case, just for your note, in their defence, paragraph 41.1 at page 209, is that when Mr. Darby rejoined KPMG LG in November 2014, he worked in the deal advisory department, not the audit team, and so he wasn't involved in the audits. That's their position. Now, as we explain in paragraph 39 of our skeleton argument, we have requested communications concerning the Abraaj group, including AH, and sent to or from Mr. Darby by defendant personnel on the basis that they are likely to be relevant to the allegation of lack of independence and professional skepticism in light of the unusual role of Mr. Darby. And so far as we understand it, what the defendants have done is that they have only agreed and have only produced communications between Mr. Darby and any of the defendants' personnel involved in and relating to the audits of AIML and ACLD. And that has produced a total of only 4 documents which have been produced. So the defendant's position in relation to relevance in respect of Mr. Darby is, one, we place express reliance on his role and his repeated movements back and forth between audit clients and audit entity in relation to our plea at 48.1. And so we seek these documents on the basis that they are likely to be or may be relevant or material to that case. And
are you in a position to challenge the assertion that from 2014, the core, by far the most substantial period in which the claimant's claims arise, he had nothing to do with audit, certainly nothing to do with audit of the claimants or AH, but was involved in the deals advisory department of the defendants? Are you in a position to challenge that? And the second subsidiary question to that would explain, as the defendants contend and rely on, only 4 documents produced on a search for relevant documents during that period.
Your Honor, the answer to that is no, not expressly. We do not have express direct evidence to the contrary. But then, in a sense, we're on the outside looking in as the claimants, so one wouldn't necessarily expect to have that evidence. What we really know is the swapping of roles, which I've drawn your attention to, and we know that because this was put forward in Schedule 2 to Jabala 12, that on the search terms that they adopted in response to these requests, there were 30,000 hits. So we know that Mr. Darby was doing a lot with Abraaj because there's 30,000 hits. So we know the swapping of roles. We know he was doing a lot to do with Abraaj because of the 30,000 hits. We have pleaded.
Sorry, that's during the period 2014 to 17, is it?
Yes, that's
30,000 hits.
Yes.
Linking documents which linked Darby with Abraaj.
Yes.
Is that what you're saying?
Yes, because if well, I can if you just bear with me 30 seconds.
Schedule 2, right?
It's yeah, the latest,
Yeah.
the later one.
4086.
If you were to go to 4086, and it may be that this is one of the ones where I need to give you.
That's
The PDF page?
Yeah.
119.
119, I think.
Thank you, I'm there.
So I think this is yes, internal 4085 for my purposes on. So this is the schedule with more details of the search terms that was provided by Altamimi on Friday late afternoon, and the 30,000 reference is one sees there in the pre-penultimate column on the right hand side.
Right, thank you. Yeah. I have
So on the, in answer to your question, I can identify the unusual swapping of roles. I can identify only on the face of it, I assume, in relation to the role he undertook at the Abraaj group, the fact of his arrest. I can identify that there was plainly applying those search terms a very, very material involvement of Mr. Dave in relation to the Abraaj group. I'm not in a position to, as it were, expressly link that directly to the audits, but
I was going to ask you the question. The word audit doesn't appear in the search terms there by way of restriction, or does it? I'm looking at the third column across.
No, it doesn't. It just has Abraaj, which is a good example of where a process of liaison may take the parties to result in really quite a radical reduction in the number of hits.
Well, you say, or the defendants say, he was involved in the deals department, if I can put it that way, simply. If he's involved in the deals department, he might well be having communications with fund managers, investment companies, in relation to that activity, deals, investments.
I can't exclude that possibility, Your Honour. I can, on the evidence before me, I can identify the quantity and volume of interactions and information, and I think it really boils down to this. In a case such as this, on this scale and complexity, with an individual with the very unique role of Mr. Darby, some form of appropriate production should be ordered so that we can test that proposition.
With very restricted search parameters.
Well, with very restricted search parameters, because on that particular point, there may end up being a community of interest between the defendants who don't want to do the work and the claimants who don't want to lose the trial date, if I can put it that way.
Very well.
And we would not be averse to that. So that's request 8 and Mr. Darby. I'm going to move away from those requests which are, as you'll have seen, have an association. And I'm now going to move to the balance of the requests, which I'm going to take, I think, pretty much in numerical order, the remainder.
Very well.
And for that purpose, please, we're going to go onto a different topic, which is requests 1 and 2, which are requests in relation to engagement letters. And can I summarize the nature of the issues that arise here.
Yes, this has been narrowed quite a bit, hasn't it?
It has been narrowed. It may be that I'll take you briefly to the pleadings to show the issues that do arise.
Yes.
Because the backdrop to all of this is some issues in relation to interpretation and meaning of the terms of business, but most particularly the limitation of liability clause and the contractual time bar. So picking it up at our skeleton argument, the claim skeleton argument, paragraph 29, the defendants have produced final versions of the 5 engagement letters that there are, including one actually that the claimants didn't have in their possession. And just for your note, I don't think we're going to need to go to them, but those engagement letters are at tabs 33 to 37 of the bundle. And so far as the balance of these 2 requests are concerned, they relate to, in relation to request 1, drafts of the engagement letter.
Yes.
And request 2, other documents relating to the drafting, negotiation and approval of those engagement letters.
Yes.
And there are 3 points that these documents go to or may go to, and I think it is common ground that conceptually these documents may go to each of these 3 issues, although my learned friend then raises arguments why on the particular facts the documents are unlikely to assist the court. The first issue is interpretation of the contract, and just for the court's note, Article 51A of the DIFC contract law identifies that preliminary negotiations between the parties is one of the circumstances the court may take into account when interpreting a contract. So
yes, you'll understand I struggled with that when I first came to sit as a judge in
well,
the DIFC.
It's always important it's always important to remember that the DIFC is its own court and has the opportunity to start fresh, and we have to take that into account. But the reference for your note is A, by which I mean the authorities bundle, A tab 16, page 267. And there is an issue, albeit a relatively limited one, in relation to the meaning of successive versions of clause 12 of the general terms of business. And let me at least identify for you the where the pleadings deal with this. The defence and counterclaim at page 103 to 104 pleads out at paragraphs 11.4 and 11.5 the general terms of business, and you will see some clauses there that deal with what one might call the allocation of responsibility and accountability as between auditor and audit client. So there's successive versions of clause 12, and then the reply to those paragraphs, which is at 182 at paragraph 16.2.2.
Sorry, give me that page number again.
182.
Yes.
Paragraph 16.2.2.
Yes.
there's a dispute as to what the meaning and interpretation of those clauses is. So it's denied if alleged that clause 12 operated to release the defendants from the obligation to exercise due skill and care in the delivery of audit services and or from liability for any breach of that obligation. The acknowledgement of responsibility under clause 12. So a particular interpretation is there identified. And very properly, my learned friend identified at paragraph 47.1 of his skeleton argument that dispute exists between the parties in relation to, or might exist in relation to interpreting the contract. Although, as I say, he then develops other arguments, which he says mean that it needn't trouble the court. So there's that point in relation to interpretation. Then there is a specific issue that arises, and I will, if we're at the, if you're still at, if you're at 183, there is a slightly more involved point, but potentially important point in relation to clause 36 of the general terms of business. That is set out.
Paragraph?
Yes, I'm sorry to make you leap about. I think it's probably easiest if you were to go back to page 107 and paragraph 113 of the defence and counterclaim, because this actually identifies clause 36 here.
Sorry, 11.13.
Yeah, 11.13. Yeah.
Just let me very quick. I've read this, but I just quick glance again.
It's a hold harmless clause, essentially.
Yes. Yep, that's right. So take me to the reply to that.
Yep. And then the reply is at 183. And there's as it were a quirk that's going to have to be resolved at trial here, which is the claimant's position is that clause 36 was not intended to operate, nor did operate between the parties, because clause 23 of the additional terms identified specific clauses of the general terms that would not apply, and those additional terms refer to clause 37 as not applying, and the claimants say that was a mistake and must have been a reference to clause 36.
Yes, I've read that, and the defendants say no, it wasn't. There's a perfectly good reason why it was a reference to clause 36.
They say that in the position of auditors, there's actually a reference why there's a reason why the termination provision should be excluded, and that's a dispute between the parties.
Yes.
But plainly, documents that shed light on the evolution of the engagement letter, particularly internal documents of the defendants in relation to the evolution of the engagement letter, may well shed light on whether that reference to clause 37 should have been a reference to clause 36 or not. And potentially a point of genuine significance, because there is a claim for an indemnity by the defendants in relation to what they say is perceived loss arising from litigation brought by funds that in some way can be traced back to actions of AIML and ACLD. So it's a point with at least on the face of the pleadings, it's a point that may have teeth. So that's the second point. And then third, and most important, is if you went back in the defence and counterclaim to 102, the engagement letters are pleaded out, and sorry, it's 110, my mistake. And
wait a minute, I'm on 103, and that's
sorry. No. It's I'm mixing up my references with my paragraph numbers. So I need the defence and counterclaim at 67 to 17. I think. You bear with me a second. Yes, sorry, 156. And starting at paragraph 67, there is a plea of contractual exclusions and limitations. And the defendants plead a number, but most important is likely to be the plea at paragraph 69 that paragraph 11.9 clause 31 of the general terms of business appended to each of the engagement letters provided the defendant's liability was limited to the amount of fees received by us for the work specified in the engagement letter.
Yes.
And I'm sure the court can readily imagine that there will be a vigorous debate at trial about whether that does or does not meet the test for reasonableness, which I'll come on to show you under the DIFC unfair terms law closely mirrors UCTA. So that's 69, and then at 70, additionally at 78, page 160, the defendants invoke the contractual time bar clause, saying
This is the 4 years.
Yeah.
4 years, is it?
Yes, it's 4 years. If you want to see the terms of that, it's set out at paragraph 11.11 earlier on in the defence at page 106.
I've looked at it.
But you have the point.
Yes.
Now, and then the reply at page 230. Pleads out at paragraphs 95 to 97, but particularly at paragraph 95, it in essence, battle is joined on whether the limitation of liability clause and indeed through to paragraph 99, the contractual time bar clause is reasonable for the purposes of UCTA. Or yes, the DIFC unfair terms law. And so those are clearly important points which the defendants seek to rely on the question of reasonableness will be important points that will have to be addressed at court.
Why do earlier drafts, or indeed collateral documents, why are they relevant and material to the court's assessment of whether the clause, allegedly binding clauses of exclusion and or limitation of liability, are reasonable or unreasonable? Why am I likely to find anything in drafts or collateral documents that will assist me on the question of that judgment?
The first of all, I think it's common ground actually that internal documents, including internal documents within the defendant, can be relevant in particular to the question of reasonableness. Now, you'll be familiar, Article 41, which is page 271 of the authorities bundle.
Article 41.
Yeah.
Let's have a look at that.
It's probably worth looking at the clauses that one is going to have. So Article 40, which is at the foot of page 271 of the authorities bundle, I'm looking at the internal. Hopefully it's the same page reference, PDF reference and page pagination, is the reasonableness test.
Sorry, I was just, I didn't have that one open, the authorities bundle. So which tab?
It's tab 17,
Yes.
page 271.
Yes, this is 271. Wait a minute. Yes, and Article 40, you said.
Yes. So why don't I just show you the key provisions first, and then I'll endeavour to answer your question. The key provisions are Article 41, which is at page 271. The requirement of reasonableness for the purposes of this law is the term should have been fair and reasonable ones to have included having regard to the circumstances which were or reasonably to have been known to it or in contemplation of the parties when the contract was made. And then there are the first sentence of subsection 2 is in determining whether a contract term satisfies the requirement of reasonableness. Regard should be had in particular to the matters specified in Schedule 2 to this law. And then 4, which is an important provision, including in the context of the question you asked me, Your Honour.
Yes.
Whether by reference to a contract term or notice a person seeks to restrict liabilities to a specified sum of money, and the question arises whether the term satisfies the requirement of reasonableness, regard should be had in particular to the resources which he could expect to be available to him for the purposes of meeting the liability should it arise, and how far it was open to him to cover himself by insurance. Now that is, you've got reasonable contemplation of the parties, where some of that will be, as it were, objective, what's known to both parties, but you've got reasonable contemplation what is known to the defendants. And here in 44, there's a particular feature which is, well, what resources did the defendants have available to them for the purposes of meeting the liability, and how far was it open to them to cover themselves with insurance? That's something that's only going to be known on the defendant's side of the fence.
Right. And so you say that documents discussing this, internal documents discussing these matters would be relevant.
Yes, absolutely. Now there might be, we don't know, that there might be internal email communications about either what level to set the limitation of liability clause. Is it fees? I mean, you might have seen sometimes it's fees. On other occasions, you might see 10 times fees, or you might see a sum of money. Or so was there some process where, for some reason, this particular limitation of liability was identified? Or alternately, if it was a standard approach that was just absolutely applied across the board, that itself is a relevant feature, irrespective of whether it's audit work or not, irrespective of whether the members of the company have approved it or not. That could be a relevant feature. And so one would expect a network firm of the Big Four to have a policy document that says we apply this limitation of liability clause in our standard terms for this reason.
So you're looking for something that might be possibly something that is fixed at the network level, the KPMG network level.
Yes, we do. We seek internal communications, but also we identify in our request a policy document. So if we look in the Redfern schedule, It's B, any internal policy, protocol or procedural document relevant to the form and negotiation of the terms of engagement in the red form schedule at 2B.
2B. Yes. Right. Well, you've answered my question, I think.
What one could identify that as, why did the defendants choose this aggregate limit on the limitation of liability clause? Was it specific to this contract and there's material emails in relation to it, in which case that would be highly relevant? Or is it just standard pro forma applies, whether it's a valuation of a business or an audit of a group with $14 billion of assets? Highly relevant in a different way to the evaluation of the court in relation to reasonableness. I should draw to your attention, although really the arguments are the same or similar, at 277 is.
So I'm just making a note. Was it essentially what you're saying is, was it bespoke for this client? Were these clauses bespoke for this client, or just general exclusion across the whole KPMG operation?
Exactly.
For whatever business it was involved in.
Exactly. Because there's actually, there will be some very interesting legal submissions at trial about limitation of liability clauses in relation to audit work. Because across different jurisdictions, it can be very restrictive. Some jurisdictions just say you can't have limitation of liability in relation to audit work, and others say that you can. So that's likely to be a backdrop to submissions about the reasonableness.
Yes, I've come across that, contrary to public policy.
Exactly.
Principle.
Exactly.
Yes.
I just highlight, as we have the authorities bundle open, at 277, schedule 2, which is referred to at 42.
I was going to look at that.
Which are the matters to which regard is to be had in particular for the purpose of the requirements of reasonableness are any of the following which appear to be relevant. The strength of the bargaining positions of the parties relevant to each other, taking into account alternative means by which the customs requirements could have been met. A is potentially relevant, and C, whether the customer knew or reasonably to known of the existence and extent of the term. Because this request is drafts of the engagement letters, which may shed light on the points I've been identifying, and may shed light on the clause 36 or clause 37, which one was to be excluded point in particular. Internal communications with the defendants in relation to these engagement letters and their terms, or policy decisions about what the aggregate limitation of liability should be, but also accompanying emails that may have been sent to the Abraaj group or the claimants in respect of the limitation of liability clause, i.e., and the contractual time bar, i.e., communications that cross the line.
Yes.
And as I say, I'll at paragraphs 47 to 48 of the defendant's skeleton, they appear to accept that in principle these categories of document can be relevant to the course exercise, but they say, well, the claimants advance their case by reference to high-level arguments reflecting the commercial generalities, the sort of broad, big picture points in relation to whether these things are reasonable or not. And of course we do, but that's not surprising because we haven't had production of the documents that might or might not shed light on what was actually going on with the selection of these clauses at the within the defendants. There is a similar point taken in relation to the burden of production, where it is said that request 1
which paragraph of the defendant's skeleton is this you're referring to?
That is at paragraph 49 of their skeleton arguments.
Yes.
And although they don't actually provide the figures there for hits, the figures for hits are apparently 20,215 hits for request 1 and 68,000 hits for request 2.
Is that from Schedule 2, Jabala Schedule 2?
Yes, that's from Schedule 2, and it might be worth looking at the
update.
Yeah, the update, which
4083.
which is 4083.
Internal PDF 118.
Internal PDF 118. Thank you.
You to your junior. So there I see the numbers, 20,000 and 68,000. Just looking at the search terms used as well.
Is alpha.
Have
Yes,
you said anything in that letter you showed me about I've forgotten the reference to it, the letter where you were proposing modified search?
yes. If you were to scroll further down to internal page 4093.
I have it. Thank you.
So there are
So did you provide a suggested custodian list? Your instructing sources?
yes, exactly. If you look at
the one above, yeah.
Yeah, if you've scrolled up to 4090 in paragraph 5C.
I've got it.
Yeah,
that's a suggested custodian list that's referred to here.
So there've been some proposals put forward. So for instance, with engagement letters, if you're looking for drafts of engagement letter, if you took a sort of bespoke phrase from an engagement letter, put that in as a search term, you would think that would dramatically reduce the number of hits, for instance.
Yes, very well.
So this is an example where one, with the focus that a hearing like this brings and the cooperation that the looming presence of the judge often brings, it may well be that we can make some progress.
I've been called some things, but looming presence.
I meant that complimentary. Those are my submissions in relation to engagement letters, and unless I can help you any further.
No, that's fine.
I'm going to move next, but I wonder if there is going to be a short break.
Yes, I'm sorry, I was going to take a short break for everybody's comfort. We'll adjourn for 10 minutes and resume at 4:45. 4 it will be, will it not? 4:45 in Dubai, 4:45 midday here in the UK. Right. Thank you.
Thanks very much, Sean.
Yes, Mr. Hubble, we're ready to proceed. I think everybody's present.
Thank you, Ron. The next category is timesheets, which is request 7A.
Yes.
And we deal with that in paragraphs 55 to 56 of our skeleton argument, and the defendants deal with it in paragraph 61 to 62. This is one where there has been very recent movement, so let me summarize the position for you. The original request was for time records of the audit teams, and paragraph 45, Ms. Jabala's 12th witness statement revealed that timesheets had been stored on a legacy system which was no longer said to be available and not possible to restore. And it was said that all that remained or remains is certain Excel files which contain raw data without accompanying narratives. As a pragmatic solution, the claimants proposed that the defendants should provide a sample of such Excel files so that the claimants can verify that that is indeed the position, as a way of moving towards resolving this request. Yesterday, late afternoon, Al Tamimi, under cover of their letter of the 27th of October 2025, provided a sample Excel spreadsheet, which those instructing me are in the process of reviewing. So we haven't completed that exercise. You will see it, although it's not going to be terribly easy to make it out, at page 4102, which is 137 of the supplemental bundle.
I have wonderful magnifying tools with one of the benefits of electronic documents. It doesn't really help, does it? I see what you mean.
Well, our position is actually there may well be relevant and useful information in here, but it's going to take us a little bit of time to analyze. It appears to provide, well, there's an explanation. If you scroll up to paragraph 11 on page 4101, which is internal PDF 136.
Yes, I'm reading it. When I said before it's not very helpful magnifying it, what I meant was I wasn't referring to the content of it. I was just referring to the appearance. It's still not entirely clear. Actually, if you put it to the extreme limits of the screen, it is clear. You can read the entries in the various cells. So yes.
You can. And what it seems to be is an Excel spreadsheet identifying work done, but with quite significant redactions in relation to it said non-Abraaj entities and unrelated non-audit, non-assurance work, which as I understand it means they have redacted where there are details of work done that is not in relation to audit. So there may well be relevant and material information here in relation to what audit work was done by whom. But we only received this late yesterday afternoon, Your Honour, and it does give rise, we anticipate, to some further questions.
Right. Do you want to put this to one side for the time being and give me any update tomorrow on any further progress with it?
Yes, that would be very helpful. I mean, I anticipate that there are some questions that may arise, and maybe we can try and resolve them overnight, which is this a sample, or is this actually whatever it is that they have? Right. It's not actually described as a sample in paragraph 11 of the letter. So
no, it's not.
Is this their best information? Because if this is their best information, for good or ill, that may be an end to it.
Subject to justifying the redactions.
Subject to exactly as you've said, possibly some explanations as to what the columns mean, but also the scale of the redactions.
Yes. Right. Well, let's move on from that then.
Yes. And that there is. I should just identify. I don't propose to go into it in light of where we've got to. I should just identify that there is an underlying issue in relation to relevance, but I suggest we come back to that if need be. I think we may have moved past this in a pragmatic, past that point in a pragmatic way. Right. But let's see if we can make progress overnight, and then update you as necessary tomorrow morning in relation to it. Then the position is similar to an extent, at least, in relation to the next request, which is 7H, which is audit manuals, which we deal with in paragraphs 57 to 58 of our skeleton argument. And the position there, Your Honour, is that particularly with bespoke e-audit software packages from the larger audit firms, what you have is an audit manual that sits alongside the e-audit software, and actually quite often has links that you would click through from the software package to the audit manual, and the audit manual provides standard guidance to the auditor about how they might go about particular audit work, what a sample size should be, or whether an audit is high profile or whether an audit is high risk. So the audit manual sits alongside typically the e-audit software platform, and so really the audit manual can't really be fully understood without having the audit files can't be fully understood without having the audit manual. And of course the audit manual is potentially relevant to whether the auditors have actually met the standards, because the audit manual will be the network's attempt to convert the ISAs into a set of standard guidance for the auditors undertaking the work. Now, that provision of that material was objected to, but the 12th witness statement of Ms. Jabala, paragraph 54, identified that there were what were described as 6 responsive CAM, which stands for KPMG Audit Manual, KAM, yes. 6 responsive CAM files, which they intended to produce as soon as possible. The link to those CAM files were likewise provided, I think, a lot at the same time as the letter we were just looking at yesterday afternoon. I think the reference is 4101, and after some difficulties with accessing the link, my latest instructions are the link has been accessed, but the material has yet to be reviewed. We anticipate, but we're not totally clear, we anticipate that 6 responsive CAM files means the 6 audit files that sat alongside the e-audit software for each of the 6 audit years from FY13 to FY17. That's what we're expecting to find, but I think this is another one where, if you don't mind, in light of the lateness of the provision of that material, we suggest that we endeavour to review it overnight. In addition, there is a small, there is a remaining point, which is the 6 responsive CAM files was the defendant's proposal for how to resolve request 7H. You will remember in the Article 80 notice that I showed you that dated back to April 2019, yes. The first item was audit manuals from 2011 onwards. So we will review the 6 responsive CAM files overnight, but we do also say that it should be no difficulty, and it falls squarely within the request for the defendants to provide the response that will have been provided to the DFSA in answer to that item 1 to the schedule to the Article 80 notice.
Very well.
So that's where we are in relation to CAM audit files. If I then turn to request 12, presentations and updates, which we deal with in paragraphs 43 to 41 to 43 of our skeleton argument, the original request was made for all presentations and updates in relation to the audits to include drafts of those presentations and updates. So that would be presentations and reports to audit committees, the Board of Governors, and so forth. So to the Board of Governors of AH, AIML, and or ACLD, and any committee of the Abraaj Group, for instance, the Audit Committee. And that resolved down to two potential issues. First, whether the defendants should produce productions or updates that were provided to AH and AH committees in addition to AIML and ACLD. And as I understand it, and as confirmed by the defendant's skeleton argument at paragraph 71, the defendants maintain that all final presentations, whether to AIML, ACLD, or ACH, have been produced. So
sorry, AH have been produced. You
yes.
said ACH.
Sorry, AH.
You meant AH. Yeah.
I did, forgive me.
All final presentations have been produced, but they take the point, I'm aware, on drafts.
Exactly. So
your response to that is we need to see the drafts to see if there's been any inappropriate pulling back or behavior of that ilk.
Yes, though it doesn't necessarily need to be that high, if I can put it that way. So there is going to be an issue in relation to the defendant's knowledge and what they did or didn't know and what they did or didn't tell those charged with governance. And drafts of presentations and updates are likely to shed light on that in any event. Then it is right to say that we have our plea that there was a lack of independence and a lack of professional skepticism applied in relation to the audits, and differences between draft presentations and one postulates an example of a draft presentation that's reviewed and discussed with management, and then it's in its finalized form that it went to the audit committee or the Board of Governors. It was in a different form. That would obviously be highly relevant and material. The defendants, as it were, take umbrage and say that there isn't a plea that the defendants were complicit in the fraud, but we don't go that far, and we don't have to go that far. We certainly say that there was an undue closeness between the defendants and the Abraaj Group, hence the plea of lack of independence, and we rely on professional skepticism. And these drafts may well be highly relevant to that. We don't need to doesn't need to go as high as complicity in fraud is the essential point. There is a similar point which you're now familiar with in relation to the burden of production that is raised by the defendants, and the latest word on that is at page 4097, which is internal 132, sorry.
Yes, I'm looking at it. 138,000.
Yes, that's the one that dropped from 177,000 to 130. I think it is, at least the one that dropped from 177,000 to 130.
It's in the footnote.
Yes, the footnote's been repeated. Yes, it's the footnote I showed you to. And so the proposal that we've made is one, to try and reduce the suggested custodian list, use their emails or use them as custodians. Two, you can have shortened date ranges by reference to the months prior to the giving of the presentations and reports to those charged with governance. There are some very broad search terms, and a particularly good example in this one is the use of the word meeting. So if you look in the third column, search terms used in the black font, presentation or meeting. So that would catch.
I highlighted that, yes.
Yeah. So one could remove terms like that. We've put forward some alternative suggestions. One could even do bespoke searches, it seems to me, by reference to particular phrases that find themselves in final versions of presentations and reports to see if they're picked up in earlier drafts.
Headings.
So that headings, phrases that are particular to those sort of presentations. We say that drafts, the differences between drafts and final presentations may be highly relevant to the defendant's knowledge and or what they should have known, and are pleas in relation to lack of independence and professional skepticism. I'm going to move on, if I may, to request 13, which is the topic of internal or external investigations, assessments, or reviews.
Yes.
Request 13 has a date range of the 1st of September 2017 onwards, because request 13 is aimed at, in particular, internal or external reviews once, as it were, the financial irregularities at the Abraaj group came to light, and as it were, the balloon went up.
Does it have an end date? It's to date.
It's to date. There is a similar request, or it overlaps to an extent with requests about reviews in respect to request 7F, which has a longer date range, but we're really concentrating on the period, the denouement, if I can call it that way.
Yes.
I can call it that.
Sorry, I'm just looking back at 7F.
You might.
Right. Yes. Decision not required, save to the extent.
Yes.
Of overlap.
So you won't find it. The full text of request 7F, if it's helpful to see it, is at 354.
Right.
But as summarized, there are three elements that we pick up at paragraph 46 of our skeleton arguments. This request in respect of internal, external investigations, it has, broadly speaking, three elements. Any engagement quality control review, the EQCR, which is the point that one of the examples in relation to request 4 in the AH audit files went to.
Yes.
Any review process carried out at the conclusion of the audit work before the file was locked down, because there's a process usually at the end of an audit where it's reviewed and then signed off, and then it's locked down and stored. And finally, any internal review instigated by the defendants upon discovery of the financial irregularities in the Abraaj group. That wording is going to need a bit of careful consideration in light of the way the evidence has unfolded in relation to internal reviews. Seems to me that needs to be made clear that it's by or on behalf of, or indeed into the defendants upon discovery of the financial irregularities in the group. And let me develop those points. I'm at paragraph 47. This is the position where the AIML and ACLD audit files appear in various places to indicate that those audit files should have been the subject of an EQCR. And the response, as we explain in paragraph 47, it is, and we pick it up in paragraph 47b of our skeleton argument, it is that it is said on behalf of the defendants, an EQCR was not involved in or required for the audit of AIML. This was inadvertently tipped due to the way the audit file was structured, wherein the group entity required the involvement of an EQCR. 2 points really follow from that. One, it's a forensic point, but it's an important one nonetheless. The audit files seem themselves to show that an EQCR was required, and the defendants' pleaded case in their further information is that the audit team for AIML and ACLD included EQCRs. But in a sense, if that's the defendant's position, that is the defendant's position. But it is another factor when one bears in mind the requests we have for the AH audit files. But there is this complete confusion about whether these audits of AIML and ACLD were high profile or high risk and therefore required an EQCR. And it said, well, notwithstanding what the files show, the EQCR was only done at the group audit level. That's really where that aspect boils down to. The real bone of contention between the parties in respect of request 13 is in respect of the third category of documentation, reviews instigated by the defendants upon discovery of the financial irregularities in the Abraaj group. Because you can readily imagine the potential, well, you can readily imagine two things. You can readily imagine that when there is a very high profile collapse of an audit client, the typical modus operandi of one of the big four is that there's an investigation carried out. And that's the first point. And the second point is that investigation will likely be carried out by experts within the network of the big four or within the defendants. And it may well shed light on, one, the factual position at the time when the review is carried out, and two, the quality of the audit work. And to suggest, as the defendants do, that it would all be sort of ex post facto opinion is a little unreal, really. If there really has been an internal review undertaken by or on behalf of the defendants by relevant experts, the conclusions of that review may well be not determinative, but certainly informative and probative for the court in relation to breach of duty. Now, it is worth taking a bit of care to understand what the defendant's position is in relation to reviews. And for that purpose, can we go, please, to the 12th witness statement of Ms. Jabala, which is at page 2582, and to paragraph 47. Paragraph 47 is about 3/4 of the way down the page.
Sorry, I obviously misheard you. The number of the page, please.
2582.
2582, 2583. And paragraph number?
67. 65. Sorry, my mistake. 65.
Yeah, I've highlighted 65 and made a note.
Yeah. So I think the words repay careful reading. To the extent that any documents exist that fall within the first two categories above, they would fall within the scope of request 7 and would have been produced pursuant to that request. So that's the EQCR debate and the closing down of the files. And then this, in relation to the third category, I am instructed by my clients that no such reviews were carried out by the defendants. And further, that if any such reviews were carried out by third parties, no reports relating to such reviews are in the possession, custody, or control of the defendants, and any communications in relation to such reviews would be privileged. Now, the court may take the view that that's a paragraph that appears to have been very carefully drafted. It appears to amount to this suggestion, or this evidence: there was no review carried out by the defendants themselves. That appears to be derived from paragraph 65. But there appear to have been reviews carried out by unknown third parties. It seems to be suggested that the reports resulting from such reviews are not in the possession, custody, or control of the defendants.
Control is somewhat difficult if there were such third-party reviews commissioned by the defendant.
It's very it is difficult. The evidence is the evidence, but control in these circumstances, as the court will know, usually has, as it were, two tests. There's one fairly straightforward test, which is on behalf of, because if the review has been done on behalf of the defendant, then obviously they have control. And then there is another meaning of control, certainly in the English authorities, which is, in practice, you can call for it. And this is plainly a very curious, or maybe it's not curious, because, but I don't want to speculate unduly. But if what has happened, for instance, is head office of the KPMG network has led the review. Let's take that as an example. Head office in London has led the review into the audit work done in relation to the collapse of Abraaj. That wouldn't be a review by the defendants, but it would be a review that one would instinctively imagine would be done on behalf of the defendants, or at the very least, within the meaning of control as understood by the authorities, that the report or the outcome of that review would be something that the defendants would call for, or would be able to call for. It would be extraordinary if they couldn't. There is, again, let me show you, please, just to finish off the evidence on this, at page 4081. I'll give you the internal page reference in a moment. It's 4081, which is 116.
Thank you.
At paragraph 10, says we refer to paragraphs. This is Al Tamimi of yesterday afternoon. Yes, of Friday afternoon. We refer to paragraph 16 to 18 of your letter. Request 13 seeks production of all documents relating to any internal and external investigations or review undertaken by the defendants. We refer to and repeat paragraph 65 of Jabala 12 and confirm that no such investigations, assessments, or reviews were undertaken by the defendants. So that's the response that we have there. We've asked in correspondence who the third parties are and been essentially told, or the defendants have declined to identify who the third parties are. In our submission, the position is sufficiently curious in the sense that it's being said there's no review by the defendants, there's been a review by third parties, the defendants aren't in control of that report, and any communications, which must mean one infers that there are communications about the reports, are privileged.
So what order would you be asking for then in the light of this?
The order, I invite the court, and we have, for my Lord's note, we have just slightly tweaked the proposed draft order at page 4044 at paragraph 14.
I've got that in a different place. I think I might have.
You might
I printed
have
it from
sent
an
it
earlier bundle.
separately.
Yeah. So give me there's a new version of the draft order. Is there in the
Well,
second supplemental bundle?
there is at 4044. The only change to it is in relation to this request 13, which is paragraph 15 of the order.
Well, what I was going to do, further to my observation this morning, requiring you to specify precisely what orders you are seeking. I've got the draft order. Sorry, what's the internal page number in the second supplemental bundle, the e-page number? Your junior has them there to hand.
Yes. So 4044, this one's in there.
Overnight, we actually found a reference to investigation by Liquidation.
Is it? It's
404 is page 17.
page 79.
Page 79. Thank you. Right. So this is paragraph.
Search for and produce to the extent not already produced all documents relating to any internal or external investigation, assessment or review, and this is the change, or review undertaken by or on behalf of or into the defendants. That is the wording that is changed in relation to this paragraph 15.
Right. And then depending on depending first of all, if there was an investigation by a third party, an external third party, or a related third party, which is not the defendants, then it would depend on who that third party was, or who was engaged in it, and the circumstances and purpose for which it was undertaken, whether there might be privilege attaching to all or parts of it.
Yes, and one is familiar in these sort of cases that, for instance, the third party might be a reference to a city law firm that has carried out the review. That would then give rise to 2 points. Point one would be, is that review really privileged or not, and on what basis is privilege claimed in respect of it? Is it litigation privilege said to apply, or is it legal advice privilege? And 2, whether that review by some city firm, wherever it might be, it was on behalf of, or at least the report generated by it is in the control of the defendants.
What about the point that this is all, whatever it is, and if it exists, it's all third-party opinion, whatever they come up with, based on materials which we, the defendants, are either willing to disclose or will be ordered to disclose, and it's not relevant for the opinion or the judgment that the court must make on the issues that arise on the pleadings in the trial.
Our answer to that is twofold. Our answer is a contemporaneous report, if there is one, undertaken at or close to the collapse of the Abraaj group, actually is likely to be to identify and be relevant to the evidential exercise of identifying what the facts were. But I do maintain that whilst that report is not going to, as it were, usurp the function of the court, and it's for the court to determine whether the defendants were or weren't negligent in the audits they undertook, a internal review carried out at the time is very likely to shed light on that issue. So those are really the two bases on which we seek those reviews or reports.
Very well. I should wait and see if Mr. Smith is going to elucidate that paragraph 65 and respond to the assumptions you have put before me as to what its meaning is. Your interpretation of it. I'll wait to hear from him as to what, if he chooses to convey the position, what the position is.
I'm grateful. Then I'm going to turn now, please, if I may, to what I think is the last substantive issue, the last request where there's a substantive issue, and that is request 15, which is documents arising from the DFSA investigation into KPMG LLP and Mr. Navalkar, covering with a date range of 1st of January 2018 to the 2nd of February 2023. And we pick up that request at paragraph 51 and onwards in our skeleton argument. And paragraph 52, we explain the position in respect of Mr. Navalkar and the DFSA proceedings and the notices against both KPMG LLP and Mr. Navalkar. And by this request, the claimants seek two narrow categories of document. The first is the evidence submitted by Mr. Navalkar to DFSA, and the second is any accounts or supporting documents in relation to AIML that were submitted to the DFSA pursuant to the Article 80 notices. And you may have it fresh in your mind, but 2678, which is the schedule to the Article 80 notices, at item 5.
Now, let me go to this because I was not clear about this. The reference to Menasa. So let me just get this up. Sorry, what was that page reference in the bundle you just gave me?
2678.
Let me go there. And what am I looking at in particular?
Item 5.
Yeah.
An account with supporting document. That's why one sees the word account featuring in the skeleton arguments in respect of request 15. It's an account with supporting documentation explaining KPMG's understanding of the operations of AIML at the time of the audit of AIML's 2017 consolidated accounts. And the reference to Manasseh comes from item 6, an account with supporting documentation of the understanding KPMG obtained to support the nil valuation of Manasseh in 2017.
Right. Now that's there's obviously a gap in my knowledge.
Yes.
I have some failure of reading, for which I apologise. Explain Manasseh. Where does that figure?
Manasseh is a reference to Manasseh Capital Management Holdings Limited, which is a company outside the Abraaj Group, to which it seems that underperforming assets were transferred for little consideration. So it seems that losses on these investments were transferred from Abraaj Holdings to Manasseh.
And does this appear in the pleadings? Because that's where obviously I I would imagine it does, or perhaps it doesn't, but I have not read about it, or I cannot recall reading about it. So where will I find the
page 276, paragraph 27.3.
276?
So this is a section dealing with the drawings made by Mr. Naqvi, and MCMHL is Manasseh. But from 30th June onwards, journal entries in the accounting replaced the debts with equal debts stated to be owed by AHH, in turn showed corresponding debts as being owed to MCLH, which set out in paragraph 9.5 above, was a private company outside the Abraaj group.
Window dressing.
And so probably I've slightly leapt in there. It might be helpful to start with 9.5.
Well, no, I think I'm understanding why I don't have any recollection of this. I know about MCM.
It's the use of initials as opposed to the use of the name,
right?
Isn't it? I suspect. In the Article 80 notice, you've got Manasseh, which is the first name of the company. You quite understandably, you've been reading MCMHL, which is the.
I also got a very helpful document which I asked for of relevant companies outside the group. I don't know who prepared that, but I did express and ask that my gratitude be conveyed to the parties for the production of that document, because I wasn't. When one starts reading a case like this, obviously there's a lot that doesn't fit into place readily. So I asked for that information, and MCMHL was referred to in that document, but not Manasseh, as I recall.
Yes. So I think the answer to the conundrum is Manasseh is MCMHL.
That's very helpful. Thank you. Sorry, you're going to give me one more reference in the pleadings. I've got 27.3.
I think it was 29.3, which is in the context of the window dressing transactions. 278. 278. Do you see at 29.3, the AIML's group FY16 consolidated financial statement showed no balance due from AIML to APEF4, which is one of the funds. Yes. This nil balance was a result of short-term cash transfer, 195 million from AML to APF4 on 22nd June. AML had received this sum from MCMHL.
Right, that all fits together now with the little note that I received about MCMHL.
Yes,
but it's Manasseh, right?
So, those are the two categories of document, and so the first category of document is evidence submitted, or evidence from Mr. Navalka to the DFSA.
Yes.
And the second is accounts that have come from KPMG together with supporting documents in relation to those items 5 and 6 in the Article 80 notice in relation to AIML and the position with Manasseh.
Right.
And the starting point we submit is the documents are obviously relevant because of the high degree of overlap between the DFSA's investigations and the allegations in these proceedings. Now, in my learned friend, in Mr. Smith and Mr. Smiley's skeleton argument at JS, his skeleton argument at 85, paragraph 85, this is the, as it were, the new legal point.
Yes, which I've also looked at the relevant law.
Yes. Now, so the court will appreciate that by that paragraph, the defendants have raised for the first time a new ground of objection, which is that in effect, there are said to be two legal impediments to production, such as fall within paragraph 28, rule 28.28. Subparagraph 2, as I understand it, or some other legal impediment to the production of that material, which is that it's said to be contrary to Article 38 of the Regulatory Law and the common law restriction against collateral use.
Yes.
Now, we submit that there are two difficulties with this new argument. The first is that it is raised late and without any proper evidence as to what actually happened when evidence was provided to the DFSA by Mr. Navalkar, and or when the accounts were provided by the defendants to the DFSA. And one would ordinarily expect that evidence to be before the court could form any proper understanding of whether the defendants' new objections have a sound evidential basis or not. And the position is that at the moment, the court really doesn't have that evidence before it. This would really seem, if it was anything, to be an argument that would have been raised under 28.29. A person who wishes to claim that he has a right or duty to withhold production of a document or part of the document must state in writing that he has such a right or duty and the grounds on which he claims that right or duty. That's really what seems to be the position here. And at this stage, I simply say it would have been a great deal better if this legal argument had been raised at an earlier stage in time, and if proper evidence had been put in relation to what actually happened with the DFSA.
Why would that make any difference? You're referring to evidence about what happened upon the DFSA requiring this gentleman to produce evidence.
It may not, for a reason I'm about to come on to.
Right. Well, I'll listen to you. But let me tell you, I'm troubled by this because we are where we are, and we are presently in RDC 2828 territory, and particularly subparagraph 2 of that rule, legal impediment under the legal rules determined by the court to be applicable. And this appears to me to be a legal rule on its face, which is applicable. And you're going to have to persuade me why circumstances in which these materials were produced to the DFSA by Mr. Navalkar are not subject to this legal rule, which may require me to exclude it from production.
Well, Your Honour, I accept the challenge. We submit that the defendants are simply wrong as a matter of law, and I'm going to come on to develop that point. And let me summarise the position. On the facts as known, that's why I raised this point about the evidence, on the facts as known, Article 38 does not apply to Mr. Milind Navalkar's transcript. The defendant's contention is wrong as a matter of law. Now, although, as I say, there's no evidence for the court by the defendants as to the circumstances of the interview, we do know from the defendant's skeleton argument at paragraph 84 It said it was a compulsory interview of Mr. Navalkar by an officer of the DFSA. It took place on the 2nd of April 2019. A transcript was produced and it was provided to KPMG LLP by the DFSA. Did you see that there?
Yes.
So if one assumes that is the factual position, that's the position that's been put forward by the defendants, then it must follow that Mr. Navalkar was an employee of KPMG giving evidence as to information obtained and closely connected to his employment. And if we were to go to page 3982, which is, I think, page 18 of the internal bundle, the update, sorry,
Sorry, I'm just busily noting, and
yeah. I'm just going to make good the point that Mr. Navalkar was an employee of the defendants at the time when he was interviewed by the DFSA. This is a witness statement that Mr. Navalkar has put in these proceedings previously for a different purpose. And it's dated the 20th of June 2021. And I just want to highlight the paragraph 1. I am a former partner in the audit department and former member of the management board of the first defendant, KPMG LG. I ceased to be an employee at KPMG on the 30th September 2019. So it follows that he was an employee of KPMG LG when the interview took place on the 2nd of April 2019, and when, no doubt, the transcript was produced and provided to KPMG LP following shortly thereafter. And our submission, based on Court of Appeal Authority, which I'm going to come on to by reference to the equivalent provision in FISMA, is that Article 38 simply does not apply to information provided by an employee of an entity when that knowledge is attributable to, and thus the knowledge of, the entity.
right.
And that applies.
Just bear with me, because this is all new. So I'm noting for the first time and looking.
Yes. This obviously isn't included in our skeleton argument because
No.
the legal argument materialised in the other side's skeleton argument.
Not a criticism at all.
But
you're going to take Court of Appeal Authority.
Yes. So let me then I'll take you relatively briefly, if I may, through Article 38 and the Court of Appeal Authority, so that you will see and have the point. And then, of course, Mr. Smith has knowledge of what our point of law is that I will develop as necessary in reply when he comes on to make his submissions tomorrow. If we start with Article 38, which is in the authorities bundle at item 15, page 252.
Yes.
The wording is 38, confidential information, subparagraph 1, subject to Articles 38, 3 and 4, which aren't relevant for present purposes. Confidential information must not be disclosed by the DFSA or any of its officers, employees or agents, or by any person coming into possession of the information without the consent of the person to whom the duty of confidentiality is owed. And our submission is the defendants, as I say, based on Court of Appeal Authority, in this circumstance, do not come into possession of the information because it's their information in the first place. Now, it's not controversial. The defendant's skeleton makes the point at their paragraph 93 that the English equivalent to Article 38(1) is FISMA, section 348(1), which is at page 278
Tab.
Tab
I've got it.
80. And it's to the same effect, but just slightly different words, differently worded. 38.1. Confidential information must not be disclosed by a primary recipient, which means the regulator, or by any person obtaining this information directly or indirectly from a prime recipient without the consent of the person from whom the prime recipient obtained the information. So it's, again, the wording here is, or by any person obtaining the information directly or indirectly from a primary recipient. And so against that background, if we could go, please, to the Court of Appeal decision of Real Estate Opportunities Limited and Aberdeen, which is at tab 10 of the authorities bundle at page 162. 162, please.
162, yes, I have that.
And if you're happy to, because I think, frankly, this will take you most of the way through to what you need to know, if you're happy to read the head note and the first holding.
I've just read it and highlighted it, yes.
Now, the material facts, and if I'll mention the paragraphs of the judgment at the same time. First of all, real estate, we submit, dealt with essentially the same position as is now before the court. The FSA investigated the defendants, UBS and Aberdeen, as a part of its investigation into the market in split capital investment trusts. That's paragraph 11 at page 167. The investigation included interviewing the defendants' employees, as well as personnel, directors and consultants. That's paragraph 12 at 168. And the class of documents in issue, paragraph 13 at 168, was transcripts of evidence given by the defendant's employees to the FSA. The FSA gave copies of the transcripts to the defendant's employer. So hopefully the court will see that at paragraph 13. So essentially the same factual circumstance as we have here with Mr. Navalkar, who was an employee of the defendants at the time when he was interviewed by the DFSA. Now, when it came to, as picked up in paragraph 13, to disclosure in those proceedings, the defendants applied to withhold, among other things, the transcripts of evidence that had been given by their employees to the FSA. And they did so pursuant to CPR 3119, which is the CPR equivalent of RDC Rule 28.29.
28.29. I see, yes.
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 The defendant's application was rejected at first instance, and they appealed to the Court of Appeal. And the Court of Appeal was thus considering essentially the same position as that before you, Your Honour, with the appellant arguing they were entitled to withhold by reference to section 348 of FSMA. And the Court of Appeal, Lady Justice Arden, with whom Lawrence Collins and Lord Justice Tuckey's agreed, dismissed the appeal. And the first issue on the appeal, if you were to go to page 170, in the middle of the page.
Can a person be said to obtain information, etc.?
Yes. Obtain information for the FSA for the purpose of section 348 if the person gives that person if the FSA gives that person a document containing information which he already has, even if he is not the source so far as the FSA was concerned.
Yes.
And the Court of Appeals.
Sorry, what was the concession? What's the concession that's referred to? I've formulated this issue by reference to the concession that UBS made at the opening of the appeal and already mentioned above.
I think it must be the sentences that follows. UBS now accepts that if any person acting in a representative capacity on behalf of UBS gave information to the FSA, for example, at an interview, and the FSA then in turn gave that information back to UBS in the form of a transcript, UBS could not be said to obtain that information from the FSA for the purposes of Section 348 of the 2000 Act.
Well, it's a matter of concession then, that essentially that is the proposition you're submitting to me in this case, and that was not the subject of judicial finding but concession, was it not?
Well, if one, I don't think that's quite right. I mean, is because what there is then careful analysis from paragraphs 30 to 33 and 34 by Lady Justice Arden as to the meaning of the word obtain.
Right.
Maybe the answer is the balance of paragraph 23, which I should have read out to you. It accepts that that person and that person alone would have been the source of that information. The question, therefore, under this issue is now whether UBS can be said to have obtained information for the purpose of Section 4A when it did not itself provide it to the FSA, was provided with it by the FSA in circumstances in which UBS already had it. So it's really looking at obtain and come into possession. What happens if the information has gone from the employee to the FSA, then back from the FSA to the employer? And if it goes back from the regulator to the employer, does the employer obtain it or come into possession of it, we would say. So really, I would submit it is the same issue.
What you're going to take me to, the subsequent paragraphs, is in anticipation, I'm asking this question, but is the point that if it comes from, in this case, the FSA back to the employer of the person who gave it to the FSA, the information on behalf of his employer, that is not an obtaining by the employer because it already had constructive possession of the information at the time.
That is essentially the point. But it's there in, well, it actually operates, the way they deal with it in the appeal is perhaps make 2 points. One, it's their information in the first place.
Right. Let's have a look at that then. So
and the second is attribution, which is really the point you were just making, Your Honour. Well, one sees this developed from paragraphs 30 through to 37 is in relation to the first issue. So
you want me to read these to pause a moment and read them, or what?
It's.
I can read them after we've finished because
yes,
it's getting close to 5 o'clock in.
Yes, shall I? Yes,
just give me the paragraph references.
If you were able to read from paragraphs 30 to 39,
yes,
that will. But perhaps I can just highlight in particular paragraph 37.
Yes.
But if you were to read 30, I therefore conclude that a person does not obtain information from the FSA for the purposes of Section 348 if he had that information before it was given to him by the FSA. That would be so even if the person was not the source of that information in the sense of having authorized some individual on its behalf to give the information in question to the FSA. And then if you are able to read through to paragraph 39, and then the second issue is exactly your point, I think when you use the word constructive, which is at the top of page 177.
Yes.
So can a person be said to obtain information from the FSA for the purpose of section 348 if he knew that information already, or in the case of a body corporate, that information was attributed to it under the general law? And 47 identifies the real thrust of the issue. It's whether in the case of corporate bodies, the normal rules of attribution of knowledge apply. Judge concluded that UBS could not be said to obtain information from the FSA if it already knew that information through its employees or consultants, applying the normal rules of attribution. UBS contends that it was wrong to do so. Then the court analyses the appellant's arguments, which are effectively attacks in relation to attribution and uncertainties in relation to the law of attribution. And then at paragraph 57 at page 180, accordingly on this issue with one small qualification dealt with in the next paragraph, I agree with it, which is to do with mistaken evidence. I agree with the judge and hold that for the purposes of ascertaining whether UBS obtained information from the FSA, UBS did not obtain any information which it already knew. For this purpose, UBS is taken to know the information known to its employees, consultants or directors, which would be attributed to it under the general rules of attribution at or before the time that the relevant information was conveyed to it by the FSA.
Well, that's what I was trying to convey. I didn't use the word attribution, which is better than constructive possession of it. But
it's the same point.
Same thing.
But we say that the Court of Appeal Authority is exactly on point. Its reasoning is sound. It's reasoning that this court sitting in the DIFC should adopt, because it's reasoning that makes eminent sense. You don't come into possession of information that is yours or information that is attributed to you. So it's as straightforward as that. And that applies to Mr. Navalkar's transcript. He's an employee. When he's dealing with the FSA, he's providing information that's provided to the FSA. It comes back again to the employer. It also applies to but perhaps even more obviously, it applies to the accounts that have gone direct from the defendants to the FSA. It's the defendant's own information. The defendants also, in their skeleton at paragraph 95 and following, suggest that there is a common law or collateral use restriction in respect of the provision of this information. We say that those authorities and that law is simply not on point. In short order, our submission is that Riddick and Crest Holmes are cases which are considering precursors to the implied undertaking on discovery, which is how the defendants identify them at paragraph 97 of their skeleton, and they relate to the undertaking not to disclose or misuse someone else's information. The same point applies. It's not someone else's information. You can't have a collateral use obligation that restricts you from deploying or producing your own information. In both instances, it's KPMG's own information, so the collateral use argument simply doesn't get off the ground.
Just remind me, the meaning of accounts here is specific, and it is to be found in the DFSA
yes, the
Article 80 notice. Just take me to that, will you, again, quickly, and I reference my notes.
Yes, it is 2.6. Bear with me. 2.678. It's in items 5 and 6. It's the an account with supporting documentation.
Yes.
So
it's confusing, but
yes, I don't understand it to mean accounts in the sense of financial statements. It means your version of events.
Yes.
Is what I understand that phrase, an account to you, to mean in item 5 and item 6.
Just let me make a note. Yes, thank you for that. Is there anything else further you want to say on that legal impediment?
Your Honour, no, we submit that Article 38 doesn't apply, nor does any rule against collateral use. So the objections are wrong as a matter of law, and the materials are plainly relevant and are easily capable of assembly and production.
Right. So is that a convenient moment? How long have you got? Anything else that you want to address on at this stage?
Your Honour, no, there are some minor points on the skeleton arguments, but I don't think they flow through into an order, and so I don't propose to take your time up with them. And I'm also mindful of pursuing the points that really matter in light of the tension Your Honour has identified between production and autumn 2026 trial, where our position is very much that this production can be provided, and we will cut our cloth as necessary because we're very keen to keep that trial date. You'll be aware these proceedings were issued back in March of 2021. Yes. The only remaining, I was proposing to my learned friend, obviously will develop his opposition, and I'll reply in relation to that. I'm anticipating that tomorrow we will also, to the extent we can, pick up the question of directions. I was going to raise one point if we had 2 minutes now.
Yes,
Your Honour, for brief discussion is.
Well, I want to give Mr. Smith the whole day.
Yes,
as you've had the whole day, but to be reasonable, you have covered a lot of basic ground that he will not now have to cover. Matters not in dispute, to set the scene, so he should have a full and equal opportunity to put his case. But there is the issue of directions, to deal with that as far as we can. I would have thought, even though I'm not going to make any decisions on the DPOs tomorrow, I think I would prefer to hear your respective submissions on directions, contingent as they will have to be, together in sequence.
Yes.
At the end of tomorrow. And
yes.
if necessary, I'll sit a bit later if Mr. Smith hasn't finished. Although I do think he can probably, he doesn't have to cover a lot of the ground that he might otherwise have had to cover had it not been for your very full coverage of the issues not in dispute before me.
Well, Mr. Smith will be, I'm sure, his thorough but nonetheless incisive self. So I'm sure he'll get through it all.
Should we do it that way then? Deal
yes.
with what you want to deal with now in the last few minutes.
Well,
but we'll deal with directions
yes.
Together at the end of tomorrow.
The only point I was going to raise now, because it might assist the parties when considering the position overnight, is the contingent question of whether there might need to be a hearing to deal with the application to amend. The thought that was going through my mind, if Your Honour is able to state it now, or alternately Your Honour might be able to check your diary overnight, it is availability for a hearing if it is necessary,
yes,
to determine an application to amend, perhaps later in November, and just simply to possibly even have some dates from Your Honour, because then the parties can work backwards to try and agree some contingent directions if it's necessary from knowing the date of that hearing.
Yes, well, I can tell you, I'm supposed to be writing awards in my other life, time set aside in November, but I will break off from that because obviously a hearing, if there is to be a contested application on the amendment application, then that needs to be heard, and I will find time somewhere in November, as early as the parties can arrange it and their availability as well. I will do it and deal with it.
That's very helpful, and that gives us a steer if we're able to give that some thought overnight.
Very well.
Uh,
I come back again to the order. So that the new order, is there only that one small amendment that you pointed out to me? And can I take it that that is the order you are seeking on all of the DPO or DPR?
That is the order which we are seeking.
Right.
If you would permit me overnight just to take instructions, it may be that it can be slimmed down potentially additionally to remove what is claimant's request 5, claimant's request 6, and claimant's request 14, because they're matters that are relatively peripheral and have been the subjects of correspondence.
Yes,
and,
well,
and I'm mindful of your encouragement warning in relation to the interrelationship between production and directions.
Indeed.
So,
and the other thing that we talked about was whether there could be some form of, if I made an order in principles, for example, if I was with you on an issue where there is a burden objection, burden of production objection. We discussed earlier a form of words that might be in the order, so that the order is made in principle, if I do make an order in principle, that there be production of the documents as requested, but subject to an agreement aimed at reducing, I'll put it in terms of the objective, first of all, reducing the number of hits so that it is a proportionate and reasonable requirement. I think it's probably better if the parties can come up with a form of words that will put the onus on them to agree a sensible set of search parameters. And this is in both of your interests, obviously, in terms of reducing the defendant's burden and facilitating an efficient conduct of the proceedings. I'll say no more than that and leave that with you.
We'll certainly give that further thought, and I think that could be a very sensible, if I may say so, approach to the problem. Potentially, I anticipate with a long stop of needing to come back to court if need be. Very much that can be avoided, yes. But I think it's the having that long stop will encourage the parties to make it more likely that they reach consensus.
Certainly, that is what I have in mind, and in whatever decisions I make, as I indicated, I don't see the need to give little judgments on each request, but there would be, I envisage, a paragraph in my reasons, which would be in the form of a directive to achieve that limitation on the burden or reduction of the burden in cases where I am persuaded, and I've made no decisions. I stress again, waiting to hear from Mr. Smith with great interest tomorrow. But if I do make orders for production, it's likely there will be in the reasons that sort of directive paragraph requiring the parties to take steps to reduce the burden in those cases where I am persuaded that there is an excessive burden as things presently stand. I hope that helps.
Very much so.
That raises one issue which I can discuss with my learned friend.
Yes.
That some of the limitations that have been suggested in correspondence effectively transform the drafting of the production request itself.
Yes, I'm conscious of that argument, Mr. Smith, and I'll certainly give you every opportunity to develop that tomorrow. Very well.
Thank you.
So shall we leave it there for today, and we'll resume again at 7 in the UK and 11 in the DIFC tomorrow.
Thank you very much, Your Honour.
Thank you, Your Honour.
Thank you. Good day to you all. Good evening in Dubai.